Yes.
And mentioning Pasa finally was a daily vote 1, serial number 1 to 8, serial number 9 to 18.
Withdrawn. Serial number 12. Special serial 9052 of 23.
Serial number 19 to 23.
28969 of 23. Withdrawn. Which number? 21. Same order. Withdrawn. Mafatar 9009 of 23.
Purport vote serial number 1 to 4. Daily vote serial number 1 to 7.
5 to 8. Not pressed since the order is complied.
Serial number 9 to 15. 16 to 25. 26 to 35.
32 and 33. Okay. Not pressed since the learned, not pressed since the respondent authorities have already complied with the direction issued by this court. Learned AGP has forwarded the orders. The same are taken on record. Full point. If any grievance survives, it will be open for the applicants to file appropriate proceedings before appropriate court.
Serial number 36 to 46, 47 to 55, 56 to 62, 63 to 71.
Yes.
This is the content of PK Lashmala, whereby we are required to file a reply. Which I have taken consent of the other side. My request for 2 weeks.
2 weeks.
Please, sir.
63 to 71, 72 to 81, 82 to 86.
Yes. Let it be called out. There can't be CA for joining party in the contempt. There is no direction.
'87 to 92 are for orders matters, 93 to 95. Then 96 to 115 are office official matter, 2 weeks time is granted. Then supplementary board filing appeal matters, serial number 1 and 2.
You say it's pre-detention. If it is pre-detention, how he can be in custody? You said he's pre-detention. So has he procured bail and then you see they don't come out for the reason that they may be arrested? Is that case? What is the objection raised? Who is the applicant? Then He has to, normally in all these detention matters, they file the affidavit. Affidavit. Only objection dispensed.
हाँ only this date नहीं है
Dispensed.
हम अभी डेट नहीं है
You should have mentioned yesterday. We cannot pass any order which the matter is not listed. Yes.
Daily Report 1, serial number 1, Mr. Viral B. Dave and Learned AGP.
Where is the checklist? Have you not prepared the checklist? Where is the order of detention? Have you not read the instructions which are put up outside the court? Three 79. Allowed. Secret witnesses are there. Secret witness to paragraph पे ले जाओ. Allowed.
Serial number 2, Mr. Kishan Daya.
Allowed.
Serial number 3, Miss Barkha R. Maheshwari.
Allowed. Secret witnesses are there.
Serial number 4, Mr. J.S. Rathod.
Where is the checklist? $397. Secret witnesses are there. Allowed.
Serial number 5, Mr. Mahito Chu Singh, Mr. M.S. Shekhawat.
No. Allowed.
Serial number 6, Mr. Kamlesh Kachchop.
Allowed.
Seven, Mr. Meg H. Shah.
Where is the order? Where is the order? Statement of secret witnesses are there.
Yes. Under 370. All are.
Allowed, sir.
Serial number 8, Mr. Kamlesh Kachchop.
Allowed.
Serial number 9, Miss Jayashree Bhatt.
Password.
Serial number 10, Mr. Sanjay Prajapati.
Allowed.
Eleven, Mr. Y Pathan.
Allowed.
12 is already withdrawn. Serial number 13, Mr. Dinesh Kumar D. Gautam.
Three 307. What is your role? In that we don't know what role you have played. Where is the FIR? 307 FIR. Two 2020 FIR. All the 2022 FIR is there. Allowed.
Serial number 14, Mr. Kishan is Daya.
Secret witness are there. Secret witness no paragraph. Allowed.
Serial number 15, Mr. Makbulai Mansuri.
No name in the FIR, but
379 there would not be any name.
directly from the name.
Allowed. Two secret witness की paragraph ले लो.
16, Mr. Sadiq Ansari.
Allowed. Secret witnesses are there. Allowed.
Seventeen, Mr. Kishan is Daya.
Secret witnesses are there. Secret witness paragraph ले लो. Allowed. 18 co-accused. 18 co-accused allowed.
Nineteen, Mr. Kishan Daya.
Secret witnesses are there. Secret witness are allowed. 19. 18 same order as of 17. 19 allowed. Secret witness paragraph is to be taken.
20 and 21 are already withdrawn. Serial number 22, Mr. M.S. Padalia.
Password.
Mr. A.R. Pathan, Mr. Y. Pathan.
How many? Allowed. Secret witnesses. Secret witness paragraph. Allowed.
Purport board serial number 1, Mr. Rituraj Meena.
Yes.
Yes, sir. The representation will be decided in accordance with the law by the additional director, public health violence. Only one request, my lords, then representation is not very clear. They may supply a fresh copy of the representation and it will be legible.
He is not going to decide.
No, I did the evidence distribution there.
It is by your client to his client.
Yes, because it is what was already part of the petition, but I think it's a big supply. Not an issue on that.
On instructions, learned AGP has submitted that the representation of the petitioners dated 30th July 2022 and 4th August 2022 shall be decided by the respond number 2.
Additional director, public health.
Addition, he is not a party.
Director is a party.
The director of health and medicine.
No, my lords, it will not be decided by.
So if he has not made representation to him, how he is going to decide?
Therefore, the issue is that these representations cannot be decided by the authorities which are made the party here. My lords. So only this can be decided by the additional director public health, and that too in a limited aspect.
You see, any one of these 2 or 3, he may decide and say that it is this officer who is going to decide and accordingly make a representation to him. The court cannot give direction to those who is not a party who is. Mr. Meena, you have made a representation to wrong authority.
What I can do is take it forward.
That is what I have suggested. He may say the officer.
We will forward it to them.
Respond number 3 will be decided. But it's the director of health and medicine.
Oh, has submitted that.
And my lords, it is also noted that it is public health.
Director of Public Health and Medicines.
Additional director public health.
He is not a party. He has not made representation to him.
All of the designation which is given, it is wrongly mentioned.
That is why it can't be, because it travels from the original writ petition. So what I will suggest that respond number 3, Director of Health and Medicine may forward his representation to appropriate authorities and he may decide it.
Within a span period.
On instruction has submitted that.
There is no such post for director of health and medicines.
No, they have posted. No.
So that is what I suggest. In that case,
Even there, these directions cannot be ordered to be implemented because your original representation is incorrect. It is not to the appropriate authorities. Office में designation is nothing. And you have not annexed your representation in the matter.
In fact, my lord, we have not received the representation from.
what I can do is I'll give a representation to them.
What we are rejecting your withdraw with a view to file appropriate proceeding before appropriate forum.
Will withdraw it.
Withdrawn with a view to file appropriate proceeding before appropriate forum.
Purport serial number 2, Mr. R.J. Goswami and Mr. C.B. Upadhyay.
Where is he? Bring him. Tushar Jalaria, who is he? Ask them to remain present. Direction is for how much? So when are you going to pay it? ક્યારે પૈસા આપો છો? This is between contemner and the court. Given undertaking by 2:30. Given undertaking at 2:30. 2:30. You see, we are only examining the willful and deliberate disobedience. Mr. Upadhyay, they have not obeyed the directions of the contempt bench also. So we'll call the police officer right now and send them behind bars. This, Mr. There are direction of division. The contempt bench has directed. Why did you not say so? That is not the, you see, the Supreme Court has, you also know that Supreme Court has clarified that. So come show your bona fide at 2:30 with appropriate undertaking that this 5 lakhs we are paying, rest of this is the problem, and we will paying it so and so date. 2:30.
Purport serial number 3, Mr. Anand Brahmbhatt.
My additional paragraph add karo. First, amning submissions. Learned advocate Mr. What's your good name? Kishan Brahmbhatt for Mr. Anand Brahmbhatt. Appearing for the petition has further placed reliance on the judgment in case of judgment of Supreme Court in case of S.K. Abdul Munaf versus State of Bengal, reported in AI 1974 Supreme Court. Ask her, she cannot interfere like this. 2066. Full point. Comma. Further reliance is also placed on judgment of the Supreme Court in Jagannath Biswas versus State of Bengal, reported in AR 1975 Supreme Court 1516, comma, judgment of this court in case of Elish Nandubai Patel versus CP Singh and others, reported in 1997 Criminal Law Journal 3169, and finally on the judgment of the Supreme Court in case of Syed Zakir Hussain Malik versus State of Maharashtra and others, reported in AIR 2012 Supreme Court 3235, and has submitted that the detaining authorities has placed line on the offences which are while placing reliance on the offences which are registered, one at Narol Police Station on 6th October 2020 for the offences punishable under section 506 into bracket 2114 fellow for 294B of the IPC. 2. Vatwa Police Station 8921 Apila એમાંથી જ લઈ લેજો પિટિશન ચેકલિસ્ટ આપી છે. નેક્સ્ટ પછી અમારામાં લખજો. Therefore, noted facts are not in dispute that the detaining authority, by placing lines on the offences which are for which the FIR are registered in the year on 6th October 2020, 8/9/2021 and 18th August 2021, have passed the order on 17th February 2023, detaining the petitioner under PASA. Full point. Thus, there is considerable time lapse in registration offense and passing of the order of detention. Full point. It is well settled proposition of that the detention cannot be ordered after an unexplained delay of so many months. Full point. Next. Allowed detention order is set. Next paragraph is what you added. The Supreme Court in case of SK Abdul Munaf Supra has observed thus para 4 level. પછી in case of Syed Zakir Hussain Malik Supra, the Supreme Court has observed thus para 22.
Per court serial number 4, 14 person, Miss Shabana Banu Tawfiq Mia Malik.
This is temporary bail or extension? સસરાના બીજા કોઈ ફેમિલી મેમ્બર નથી? Have you verified? Verify by 2:30.
In a diva gap. Regular daily board, serial number 1, Mr. Kashyap R. Jani, Mr. Deepak P. Sanchela and Leonard AG.
Learned AG, pursuant to the order dated 6 June 23, Learned AGP has forwarded the communication order dated 13 June 23, approving the order passed by the Nagar Palika. Full point. Yes, anything remains? Accordingly, the respondent authorities shall pay the benefits accruing out of such orders within a period of 3 months. Learned advocate Mr. Jani does not press this petition, not press disposed of.
Serial number 2, Mrs. Nasrin N. Sheikh, Miss Sejal K. Mandavia, Mr. Chaitanya S. Joshi.
Yes. Pursuant to the order dated 5th June 23, Learned advocate Mr. Chauhan has tendered the communication order dated 2nd June 23, whereby the benefits arising out of the judgment or order of which the complaint sought, is paid, has been sanctioned, and accordingly the same will be paid. Full point. Next, accordingly, the respondent authority is directed to pay the necessary benefit within a period of 2 weeks. Then Advocate Mr. Nasrin Badudar does not press this petition at this stage, with the liberty to revive in case the order is not complied with. Pursuant to the ऊपर लगी जो order is also the officer so and so नाम आपी दे जो registrar नाम आपी दे is present before this court.
Serial number 3, Mr. Aditya Gupta.
It is not playing smart with me, but playing fraud with the court. I can-
Party. नाम आपी दे।
Let us see first. Let her submit. I will call upon. Wait.
As per the requirement of the CA madam, my lords have valued the direction of this honorable court. That is, it was directed by this honorable single judge. In view of setting aside the charge sheet, the respondent authority shall pass consequential order.
Where you are reading?
Original order
Original order
of November, which is at page number.
Page.
Now we would after filing affidavits,
May I
after
submit?
having
Mr. We have- We'll call upon you. Please let us.
page 30,
Where are the first directions?
38.
The passed within period of the same shall be passed within consequential order in accordance with law. Minus we have granted him post minus.
After this order,
After this order minus.
what happened?
Minus, may I submit minus, after this order, once we have granted him a post of deputy mamlatar at Mansa. Minus he did not remain present there. Minus thereafter subsequently post of mamlatar at Narmada, which denied by the collector that we don't want him, but thereafter minus it was directed by the department that you have to take him, and minus thereafter this order which minus I supplied, the RAC according to the telephonic instruction that you can appear, you can take the charge of mamlatar, but minus
This I
he
have
did
got
not.
it yesterday evening at 6:42.
Yes, then
And 6:42 yesterday, she is finding fault with me.
today there is an order in your favor which they have passed. No
what
posting.
happened
Will
is- No order is passed. I tell you, Lordship, this is where I am alleging contempt. Lord, on 25, for just give me 2 minutes, Lord, and please close this papers, Lord, for 2 minutes.
You don't want to? Yes.
No, I want to remain present. 25/4 is the
When you will remain present?
tomorrow, but not only that doesn't. No, only 1 minute. Only 1 minute. 25/4 was the order of promotion. I have not seen, my lord, order of promotion without posting. Posting order was passed on 29/4. Served by AGP to my friend on 5th. Therefore, now see the order of 5th. 5.
Today,
No, only 1 minute. My lord, they're finding fault with me.
now forget about that fault.
No.
Today you are reporting or
Just-
not?
I have to report.
Report.
Why should I not, my lord?
So
But
report.
no, only thing is I want to tell your lordships is matter is there are 4 other issues also, but 1 minute.
That those all are minus sorted minus.
एक मिनट मैंने आपसे एक
The other
Lord,
issue was with
on
regard
5th when I got, on 6th I reported. I said they said we don't want you because you are due to retire. Kindly see this.
That
Lord.
you had mentioned earlier.
Earlier on 12/5 department wrote a letter,
Hmm.
Statue of Unity, that please give us somebody who has a longer tenure. અને મને 13 દિવસ માટે પાછો ત્યાં જ મૂકે છે. અને where I am hurt at is કે તમે હાજર જ નથી થયા અત્યાર સુધી. Please see the order.
Now we are not concerned with that. We are not
This have been a
concerned.
break done say. They will consider this as a break.
Then we are not
99
concerned
days
with
are
that.
regularized when subsequent order. 99
Learned
days are
AGP has
regularized.
forwarded the
Thereafter,
order.
the higher pay grade is also minus
forwarded the order dated 12 June 23 along with the
On WhatsApp and
orders
yesterday
dated
6:42.
full point. She has submitted accordingly directions are complied with since the applicant is ordered to remain present and is posted at
Statue, same place. જ્યાં મને સવા મહિના પહેલા ના પાડી.
statue of whatever or
Statue of Unity.
statue of unity. Full
Where
point.
I was denied.
Now we forget that. Learned senior advocate has submitted that the aforesaid order was received by the present applicant at 6:45 in the yesterday
Again, they will
evening,
find fault 6:42.
at evening of yesterday evening,
Fine.
and the
For me, they
applicant
are fighting for every word.
will be reporting to the aforesaid place tomorrow.
You know, I will not look, it will not look bad on my part. એક મહિનાથી ગાંધીનગરનો order file ઉપર તૈયાર છે. હું જો અત્યારે એમ કઈ કહું તો એમ થાય કે મારે ગાંધીનગર જવું છે. That's why I am not saying. As an employee, I don't want to choose my.
You see, contempt proceedings, we cannot even otherwise delve into all these issues.
Yes.
We have to see
Only
the
thing is
compliance.
she has regularized 99 days period, but Lordship may clarify that this may not be treated as a. કારણ કે મને 25 ચાર્જ.
We in contempt, we cannot clarify. Accordingly, it is submitted that the applicant will report tomorrow full point. Next, the orders dated so and so are taken on record. So far as the other consequential benefits is concerned, learned AGP has submitted that
સર એ કાલે રાખો હું જોઈ લઉં.
the
Day after tomorrow. I will have to
orders
see.
are also passed. Full point. Next, if the applicant is agreed by any of the actions or the subsequent orders, comma, he can file appropriate proceeding before appropriate court. Full point is well settled proposition of law that in cases of willful and deliberate disobedience, the contempt proceedings can further be continued and charge can be framed. Full point. This court, in view of the subsequent development after issuance of the notice and orders passed by this court,
No,
there is
there are
substantial,
conflicts.
there is substantial
No, no,
compliance.
contempt it will go. In contempt it will say. You know, seal cover is open. I'm-
We will see that whatever action you want, you can do.
No, only thing is, Lord, your Lordship may kindly keep this till day after.
No, no.
But I will have to see what is in. I will
We
not
have
travel beyond
clarified.
order.
We
I
have
will-
clarified that whatever it remains, you can file appropriate. Now,
Lord, I
there
will-
cannot be a willful
Lord, please see this
disobedience.
affidavit. Please see this affidavit.
Now, we'll take that also.
It is fine. Just permit me to read. I am not tendering across the bar. It is fine. But possibly papers are not there. That's fine. I am
It
not
is there.
tendering
We are
across the
having,
bar.
we are having.
Please see, my lord.
Hmm.
All that is about two things we not required to be seen.
Hmm.
Promotion is given now. How can it be notional once the inquiry has gone?
Learned counsel has further submitted that the promotional is given notional to the present applicant and is also agreed by the same. Anything else?
Yes, promotion
हमने
is
अभी
given
ये
notional
पाँच
and
कॉपी को
seniority.
And-
99 days regularization. Lord, a notional promotion.
Is agreed by the same. પછી એમાં આગળ લખ્યું. Learned
This is
AGP
contempt,
को
Lord. This can't be notional.
challenge the order. Next. And in our considered opinion, comma, there cannot be the orders which are subsequently passed. The further contempt proceedings cannot be continued and no charge can be framed as there is substantial compliance of the orders. If there is any grievance still survives of
On
with regard to the promotional high pay scale or any benefits, it will be open for the petitioner to file appropriate proceeding before appropriate forum.
and also seniority.
Seniority also, etc.
Please, Lord.
Chalo, disposed of.
My only worry was just it's a very serious issue because I would be retiring on 30th. It will affect my pension and everything. That's why please be kind enough to do it. Not on 25th they passed an order. They did not say anything on posting. On 29th they said posting, but never served to me. It was served on 5th. To
I
Mr.
am repeating, we have already
The only
considered.
thing is not what about this?
You can challenge. We have said whatever grievance remain, file appropriate proceedings. Chalo, next.
Serial number 4, Mr. Shivang P. Jani, Mr. A.R.
That
Thakkar.
can be sorted out for the poor man who is.
You see a contempt proceeding, you know, Mr. Oja.
No, why I am
You
worried. I
cannot
tell
go
you
into
what,
merits of
No,
that.
no, I would not have. Just 1 minute. But I know I'm not encroaching upon your lordship's. decision.
Definitely.
Yes, but sometimes Lord, I'm sure your lordship generosity that your Lord, both my lords have been permitted. But
Yes.
only one line is more, and that will have to be clear. કે તમને કહેવા છતાં તમે હાજર નથી. Please see that. That means
We said any grievance.
only thing is not that you will, they will have to
Clarify. Whatever you may seek clarification from them. Yes, Mr.
clarify.
So that as per the director of the government, yesterday when we received the letter and we tendered the check of rupees 14 lakhs. So her client is refused to, his client is refused to accept this check.
According to the petitioner, it is not the amount directed by the project manager and according to the calculation of the petitioners.
Loco. Special MCA number 555 or 2023 pursuant to the order dated 4th May 23. Learned. Where is the check? Learned adequate. Mr. So and so has submitted that as per their understanding and calculation amount, a check of rupees 14 lakhs 67,977 was all tendered to the applicant. But however, she has refused to accept. Full point. Learned advocate Mr. Jani has submitted that there appears to be some error in the calculation and the applicant is entitled to more. Full point. Next, in the present application, the applicant is seeking directions. Applicant is seeking for the compliance of the direction issued by this court with a judgment and order dated 28 February 2022. Passed in caption repetition, more particular para 4. A bare perusal of the aforesaid direction would reveal that the court has not mentioned any particular amount which should be paid. The only direction which are issued is with regard to the payment of the benefits as mentioned therein. Full point. The respondent has already conveyed the applicant to collect the check of the aforesaid amount. However, she has refused to do so. Hence, this present application seeking initiation of contempt of proceedings cannot be entertained, as there cannot be a willful and deliberate disobedience. If the applicant is desirous of accepting the said amount, she may do so, and any grievance with regard to the calculation or payment of the amount remains. It is always open for the applicant to file appropriate proceeding before appropriate forum. With these observations, the application stands rejected. Chalo, next. It is, we don't know whether she want to accept it.
Serial number 5 to 8 are already withdrawn. Serial number 9, Mr. Jamin are the way.
So the last opinion I could require. There are several departments involved in this matter. And we need 4 weeks time. As far as the Panchayat department is concerned, we have to, the approval is sent from the Panchayat department to us, and then we will send the proposal to the finance department. As far as the health department is concerned, the education department is concerned, we will send the proposal to the finance department, which can be completed within 4 weeks.
So everything in this order will be complied within how much?
Within 4 weeks.
We will grant you 6 weeks.
Please, sir. Only for the Panchayat, the Panchayat has to send the proposal to us and then send to us.
Panchayat also is your department. So whatever you do, we'll say within 6 weeks comply. Learned AGP on instructions has submitted that the direction issued by this court with the judgment and order dated 28 June 2022 passed in caption repetition shall be complied within a period of 6 weeks. Whole point. It is submitted that since various departments are required to be consulted, it will take time to extend the benefits as ordered by this court. Accordingly, the present application is disposed of with the direction that the respondent shall comply with the direction issued in paragraph 5 of the judgment dated 28 June 2022 within a period of 6 weeks. Full point. Liberty is reserved in favor of the applicant to file the present contempt petition in case the directions are not complied within 6 weeks. It is clarified that in case the directions are not complied with, the court will be constrained to impose personal exemplary cost on the officers who are responsible. 9 and 11. 6 weeks we have stated.
Serial number 10, Mr. Nikul K. Soni.
Yes.
The seniority is given since February. The content won't lie. In the civil matter, affidavits have been done. This order was to give seniority. There was no word of promotion in the order. Promotion has been given, but seniority is not.
So they have given now.
Column number 5. The seniority was to be given from the date of appointment. Recruitment type 2007, 9 and 9. Then column number 8.
Readjusted date of seniority.
After considering of CCC.
Yes.
Since the date of their adjoining, and this is done since before filing of the contempt.
This order is passed with regard to a transfer. Please for transfer on completion of marriage. There are 3 of the judgments.
This is from the date of their joining.
The order is passed with regard to the transfer. We want seniority from the date of joining.
What is your date of joining?
There are 12. We were appointed in the year 2007 to 2009.
Where is Perat?
There are page 12, there are 4.
They have given from same date 2007 and 2009.
That is date of passing of the valid.
Why they have given from 14 September 2007.
This is done in February 2023 before even filing of the contempt petition.
In this order which I have annexed.
Page.
It is not there. Page 35 is the order of promotion.
Page.
Page 35.
Yes, but then pursuant to this is promotion can only be given after they have fixed your seniority.
Before that, we have made representation. No reply on that was given to the.
But are you not supposed to verify that they have counted your seniority and this order is of February 23? It was already published. Addendum was already published.
We have never been supplied this.
They are working with us.
Otherwise, why would we file contempt?
Addendum, it says addendum published on 14 February 23. And the seniority, readjusted seniority is from 14 September 2007, 1st August 2009 and 1st September 2009.
They are working with us. That is job.
Let me take it.
1, 2 and 3. It is in your, you see, you have stated so. In the order itself, it is recorded that you have appointed in 2007 and 2009. Then,
We are appointed from 2007 to 2000.
so we,
Because I have not been pointed out by them.
today they are pointing out. Are you not supposed to verify? Then,
I have asked.
14 February નું છે, 21/2 નું છે.
This order doesn't say anything about that. 21st of February 2020. First paragraph.
Anyway, they have complied. So you have fixed their day from seniority from date of appointment.
Yes.
Learned AGP on instructions. Give the name of the officer. So and so has submitted that the seniority of the appointment is already fixed from the date of their appointment with a order dated 14 February 2023. In this view of the matter, learned advocate Mr. So and so does not press the contempt procedure.
Serial number 12, Mr. SP Majmudar, Mr. Rushabesh Muncha.
Same year, same thing. We will dispose of, earlier we have disposed. They will grab 6 weeks, they will
With the liberty revival.
with liberty to revive and exemplary cost in case they don't. જે કયા મેટરમાં કર્યું ઓર્ડર
9 and 11.
9 and 11 નો જે ઓર્ડર કર્યો ને એ કરી લે.
Serial number 13, Mr. Ashisham Dagli.
Also, pursuant to the last order, the court orders, I will instructed my officers. At the outset, my lord, I would submit that the proposal which was sent, that was way back in month of October.
જૂન.
No one. This is the communication methods which I have received. My lord, the proposal for detaining under PASA methods, the proposal from the police station to the PCB office, my lord, it was sent way back in month of January. Thereafter, my lord, no order has been passed. And that is the instruction.
So what is this then?
Yes, my lord. There is some mistake, my lord, in framing the sentence. Actually, they cannot, the police station cannot say that it is anywhere. They can just say that that order is not being yet approved. Yes, ma'am. That is, my lord, that is a mistake on the part of my office.
So ask him to be careful in future. No, they said it is not there.
It has not been yet been approved, my lord.
It is not approved.
Pursuant to this two FIR, there is no order that is not a statement.
Yes.
Yes, the statement is very clear.
Learned AGP, pursuant to the order dated 9 June 23, learned AGP on instruction submitted that the communication dated 6/6/2023 passed by the concerned police inspector is incorrect. And in fact, due to grammatical error, such mistake has occurred. Full party has submitted on instruction that the authorities does not propose to pass any order of detention and is not approved for the offences as mentioned in the present petition. Learned advocate Mr. Dudley does not press this petition at law.
Serial number 14, Mr. Dhruvin U. Mehta. Pasa fresh.
Rule seriatim.
Serial number 15, Mr. P.S. Pathak. Ms. Reena Kaman.
This is for where is the award is not contempt does not lie.
After filing the contempt of their file the petition and then they get me out the honorable court has issued notice awarding cost of ₹15,000. Now not my notice at page number 36. Now the government level officer will say that the matter is sub judice. For reinstatement will not.
The present application number 420 is filed for seeking compliance of the direction issued by the labor court.
Tomorrow I will bring some judgment.
Are Amna side can carry it. Listen to the page 39. Yes. Which decision?
That in Murjibai case, the reasonable court has held that the contempt of award is not reasonable. The honorable division bench held that in that matter in Murjibai case, the judgment of the honorable Supreme Court.
Which Supreme Court?
In an income tax appellate tribunal, the last paragraph.
Upon jara 1990 supplement. Wait. Which judgment of Supreme Court?
judgment was not.
We'll see. In this judgment, was the award was sought to be implemented?
Please,
Which judgment? But
my lord, we take 240
no, right now we'll put an end to it.
and the other one is 81 GLR page number 107.
Upon 81 GLR.
1070.
1999 volume 1 SEC page 16. બીજું 99 વાળી મળી
99 one SCC ને
1999 volume 1 SEC page 16. (1995) volume 2 GLH 550 આપજો. (95) volume 2 GL. 95 volume 2 GLH 550.
81 છે. રહેવા દે હું લગાવું 95 2 GLS કાઢો સામે પડ્યા છે.
(550)
બીજું કાઢ્યું 95
3-judge bench, Supreme Court. You must be aware, but deliberately you have not shown it. Upon jara. Ah. This is 3 judges bench. Lakho. We'll dismiss it with cost. Why should we not? You deliberate, you knew it. You are aware of all these judgments, but you are not aware of the judgment against you.
No, I'm not, barely stating otherwise not about suspected.
So still you are pressing, or shall we reject?
Can it be
230.
for tomorrow? I can put my aspect.
230.
CL number 16, Mr. Vishal P. Thakkar.
Yes,
One of the order is on page 15, wherein the order was data code was confirmed by the computer court.
yes,
On page 16 is the first representation.
yes.
Very, a very weird reply has been given that you have written date of.
So you want execution of the award, not maintainable, rejected.
This honorable court has confirmed the
Then there should be a direction that now it is their petition, this is dismissed. There is no direction that now the award or whatever consequential benefits are required to be paid. Yes. Rejected. 230. Next.
Serial number 17, Mr. Nirav C. Thakkar.
Page. Yes. What is the date of the order? When you filed this petition? After 1 year.
Time of 6 weeks was given to decide the referendum.
Yes, so then also it would not be.
It will be the end of March of 2022.
Yes,
that
count
the,
it.
That the contempt will technically start kicking in. So page 11, if you are-
So it was in April you have filed.
I'm not aware of the exact date.
13th April, it shows 13th April, 23.
The date of affirmation is 16th April and March 2020.
That doesn't mean that you have filed in time.
Just take the date. From the date of receipt of the order. Because if you watch the page 11 for a moment, sir, the
Yes.
representation be decided by the respondent being used.
So when they were aware, when this,
That I would not know because the rate would be set by this honorable court. I have to ascertain that.
yes,
But the fact remains that the representation is not decided. I
you see
reminded them on several
representation,
occasions.
first of all, point out that you are in limitation.
Because I have to check because the date on which the.
Check.
the
Learned
order
advocate
was
Mr.
received.
Thakkar requests for some time in order to verify the date on which the opponents have received the writ of the order of this court. Next week.
Mr. Murli and Devnani.
The interest part was not there. Today I am given another communication where they have considered the interest.
6%. Learned AGP has tendered the order dated 12 June 23, passed by the executive engineer Sipu Yojana Division Palanpur. The same is ordered to be taken on record. Full fund accordingly. The respondent shall give the benefit, give the actual benefits of the offered order. In this view of the matter, learned advocate Mr. Devnani does not press the present contempt petition.
19, Mr. R.K. Mansoori and Mr. A.S. Timbalia. Notes, Mr. Man.
Learned advocate Mr. Mansoori has filed a sick note. The matter is kept on Monday. If learned advocate Mr. Mansoori is desirous of filing a sick note or leave note, he shall make an alternate arrangement.
Mr. Narendra L. Jain.
Yes.
There are three orders, there are not the relevant is beginning from page 10. You may not take the honorable court to the entire order, but page 19 below is the eventual direction.
So you are seeking, no, which order is of the High Court is not complied.
So it is
Then-
of the executive magistrate pass under 145. These are 145 proceedings instituted, my lord, the facts are required.
So under which provision are you seeking?
Lords, if I may read, lord.
Contempt of court. Which provision?
Lord, civil contempt, if I may read, civil contempt means willful disobedience to any judgment, direction, decree, direction, order, writ, or other process.
It is
of
why
the
it's
court.
common, its entire contempt of court act is based on that.
Yes, my
For
lord.
the contempt of subordinate courts, which provision?
Contempt of subordinate court, lord.
Which section?
Lords, criminal contempt, lords.
How can there be a criminal contempt in the violation of any order?
Lords,
Are you aware of the difference between 2B and 2C?
lords, if I may read 2C, lord.
Read 2C.
2C, criminal contempt means the publication.
So you want an order of non-compliance of the direction issued by the magistrate court?
Lord, it is an executive magistrate, the difficulty that there is some limitation that I have, lords, I understand that my
You
only.
see, contempt of court act is a very harsh act, and it has to, the provisions are to be seen or viewed very strictly. It can't be that mainly because you file and say that we call upon them. This application is filed under section 12. How it is maintainable under section 12?
Lords, if I may so submit, lords.
Yes.
My difficulty is this wise, the reason for pursuing this petition was, if I may give a brief history, lords. I am a person who has purchased a home. I was residing in that home. I was attacked by a group of 25 people. I approached this happened in the city of Ahmedabad. I am attacked by a group of 20-25 people.
You see,
and
maybe
thrown out.
whatever has happened, you come, how this petition is maintainable, just point
If
out.
I may, Milords, I am aware there are some limitations.
If
as
it
far
is
as-
limitation, we can't help it. You have other provisions of law effective.
But in fact, Milords, I have verified for implementing an order under section 145, there is nothing that is provided for. And therefore, Milords, I could think of this for.
Are you sure that this order cannot be in any matter be complied by anyone else? We'll record your statement.
Yes, Milords, I have done that work. It is not that I am making. a
So how
statement
this
that-
state, this application is maintainable under section 12?
Milords, may give me a minute. If I may just state the facts and I will.
No. We'll go by the, why should we enter in contempt proceeding? We cannot examine the fact merits. We have to see the directions, whether they are complied or not.
Yes.
You have filed this under section 12. How this application is maintainable under section 12?
Lords, I would humbly submit if my lord may kindly permit me to read 2C3, interferes or tends to interfere with or obstructs or tends to obstruct the administration of justice in any other manner.
Hmm.
And if my lords may kindly peruse what the public servant, the police officer has done, I have asserted on both, I have
Yes.
asserted before the higher superior officers also at page 51.
Hmm.
સબ ડિવિઝન મેજિસ્ટ્રેટ સાહેબે 3/4/2023 રોજ ફાઇનલ હુકમ કરી અમો અરજદારને કબજો ભોગવટો રિસ્ટોર કરવા માટે પીઆઈ શ્રી સોલા હાઈકોર્ટ પોલીસ સ્ટેશન નાઓને સ્પષ્ટ હુકમ કરેલો હોવા છતાં અને અમો હુકમ થયા બાદ બે વખત પીઆઈ સાહેબને આ હુકમનું પાલન કરવા વિનંતી અને આજીજી કરવા છતાં પીઆઈ સાહેબ સદરનો હુકમનું પાલન કરવા તૈયાર હોતા નથી અને અમોને સ્પષ્ટ જણાવે છે કે આ હુકમના અનુસંધાનમાં કોઈ કાર્યવાહી કરવાના નથી અને કોઈ તરફથી તાળું ખોલવામાં આવશે તો તેની સામે પોલીસ કાર્યવાહી કરવામાં આવશે. આથી પીઆઈ સાહેબના આવા કાયદા વિરુદ્ધના કૃત્યોનો what happens is that I am a person who is rendered homeless by way of an attack. There are civil proceedings pending. Bypassing those civil proceedings, I am dispossessed of my only residential home. The police chooses not to take
Civil
action and-
MCA number 798 of 23 on a specific query raised by this court that this application is maintainable under section 12 of the contempt text. Learned advocate Mr. So and so has invited the attention of this court to the provisions of section 2 into PSC. We are rejecting the application.
Then I may be permitted to withdraw and pursue some other.
Withdrawn to us at this stage, withdrawn with a view to pursue, with a view to file appropriate application before appropriate forum.
Okay.
21, Mr. Swapneshwar Gautam.
Yes.
Verify with regard to some matters were pending before the Supreme Court, whether there is a stay or not. A stay
Yes.
These are the orders where in one of the SLP, the contempt proceedings have been stayed. Just in other SLPs, the SLPs are dismissed.
We can't help it. It is on the Supreme Court. Invite the attention of the Supreme Court.
In the main appeal against the Chetan Rajguru order, only notice is issued, which has been so observed by the division bench. I know the fact I cannot. Then my request to the honorable court that this matter be signed by action, and as soon as the decision of the honorable Supreme Court.
Mr. Contempt, first of all, what about the limitation? It cannot be that though the contempt is not made out, still the application may be kept pending. What about the limitation? Not pressed at this stage.
Then liberty.
Liberty to file appropriate at the appropriate time. Chalo.
That's okay. 22, Mr. HB Singh.
May I request the document as the proceedings are- Supreme Court
Since the issue is pending before the Supreme Court, learned advocate Mr. Gautam has submitted that, as well as learned AGP has submitted the issue is pending before the apex court. Hence, it does not press this petition at this stage. It requests liberty to file appropriate application after the issue is decided by the Supreme Court. The request is acceded to, matter is disposed of as not pressed at this stage. Yes,
22, Mr. HB Singh.
Serial number 20 to 28.
yes.
Dealer of irrigation department, but the districts are different. Thus, marriages for 3 weeks children, this can be adjusted for 3 weeks children. All the departments are instructed that in all the matters, the compliance will be done.
So we'll dispose of in your will liberty to revive. We'll grant you 6 weeks time. In the same order will pass. Same order pillar 9-10 month leader change. Within 6 weeks they will comply. If they don't comply, liberty to revive and exemplary cost.
20 to 28.
22 to 28.
81 is already complied. As and when it is called out, I will
81 is already complied with.
give the paper. As and when called out.
As and well called out.
Serial number 29, Mr. Vijay H. Patel. Sick notes.
On 6 June 23, this court passed the following order. Today it is reported learned advocate Mr. Vijay Patel has filed a sick note. Full point. The matter is kept on Monday. If learned advocate Mr. Vijay Patel is desirous of filing any sick note or leave note, he shall make an alternate arrangement. Top of the board.
Thirty to 33 are already withdrawn. 34, Mr. Kirit I. Patel.
Yes. What happened thereafter? Thereafter, what happened? Where is the notice? Yes. Issue notice, returnable 2 weeks. Meanwhile, the respondents are directed to comply with the directions issued by this court with a judgment and order dated 14th October 2022. Failing which court would be constrained to frame charges against them.
35, Mr. San Associates LLP.
35, 37, 39, and 40 are complete.
Not pressed since the orders are complied with.
Mr. Ullas N. Goel.
Yes. Thereafter what happened? Hmm. Which is the authority? Which respondent? Which respondent? Yes. Take instruction is only deciding representation. We'll take it tomorrow, Monday. He has made a representation, page 21, decide Monday. On the, learned AGP shall take instruction as to, with regard to the time frame in which the representation is can be decided. Monday.
37 is already disposed of. Serial number 38, Ms. Shika D. Panchal.
Yes.
This is similar to the other matters. Where the orders are. The same 19/7 consumer are no compliance, 14/4 to be paid. This is the second round.
Notice
The direction is
21st June 23.
(39) and 40 are already disposed of. 41, Mr. Yogen and Pandya.
After that, what happened?
page number 12. Originally, it was page number 17 and 88.
This is the order of 23rd January 2020.
Thereby, the university was not working at the teaching for online. Thereby, the PA was paid out for this. That I even stated in my complaint.
This is not maintainable after the limitation period of 1 year.
There was a time to be granted for this.
Time is granted that preferably within a period of 8 weeks.
They are not compliant with it.
Of special MCA number so and so, so and so. The upon contempt, present application is filed seeking compliance of the direction issued with the order dated 23rd January 2020, more particular in para 12. Para 12 ले ले. Full point. The respondents were supposed to comply with the aforesaid orders as per the direction within a period of 8 weeks. Full point. Next. Thereafter, the petitioner for the first time had approached on 4th May 23 by making a representation for granting the benefits arising from the order dated 23rd January 2020. As per the provisions of section 20 of the Contempt of Courts Act 1971, which reads as under, the application for, the limitation provided for actions on the contempt proceedings is 1 year, and no further contempt proceedings can be initiated after expiry of such period. Thus, the limitation ended after a period of 8 weeks when the order dated 23rd January 2020 is passed. The present application for contempt has been presented on 2nd June 2023. Hence, the present application is barred by limitation under the section 20 of the Contempt of Courts Act, and the same is rejected. Next. or it is clarified that it will be open for the applicant to file appropriate proceedings before appropriate forum, seeking the benefits. Arising of this said order of which the order of the benefit is, sorry, compliance is sought. Next.
42, Ms. Devanshi N. Kakkar and Mr. Devansh N. Kakkar.
Where are the directions?
Page 17, para 7. Each of the above between order dated and post on part of the case. Now, in the original application number 2 and 15, if you have confirmed the petition department subject to absorb the respondent here in terms of the direction issued by the board in event of this board in special civil application number 6 on 66 of the
This is of 19th April.
yes, ma'am.
You have filed on 5th June after the limitation.
Board stamp was given to the date of receipt of the
When it was,
it would have expired on 19/5/2020.
when did they receive? When did you serve?
Exact date of receipt of the writ is not available.
Then you have to verify. On the request of learned advocate Mr. Devansh, what's a good name?
Manan Paneri.
Manan Paneri for Miss Devanshi M. Kakkar. The matter is adjourned on 11 July. Since we would like to verify the date on which the respondents have received the writ of the order of the judgment and order, of which the compliance is sought.
43, Mr. Vaibhav Vyas.
Then what happened? 30. In this, we will impose personal cost. Even if you say that tomorrow you will comply with the order. 25,000 cost personal on who is the officer who made a statement? His name is recorded in the contempt proceedings. R.K. Bagora. 230.
For Miss Archana Acharya.
Status quo of the land till final disposal.
And now what is the issue of a registered banner at 54 crore and more.
Page.
The banner will start at page 12. And the constitution card, my lord will see. On page 20.
Here, this is Banakhat only, but whether this
Yeah, but banner, this is not just the banner, sir. They have accepted the consideration.
Name, but that the status is not yet of the land is.
Right has been created by way of this document, sir.
The court said maintain status quo of the land.
Yes, sir. Now they are executing the banner, sir, giving the right to the third party. Let's create a something. If my not permit, I just one is of our.
Okay.
I have mentioned in my memo.
Yes.
There are Gujarat High Court judgment that is,
What was the order in this? So maintain status quo of the land.
yes, injunction has been granted.
No, injunction would be different.
For maintaining status quo with the registered Panaka has been executed and the constitution has been accepted, then it creates a third party right. If it's a third party right, then status quo order is free. That is the
There is no direction issued with regard to the non-creation of third party right. So what do you mean exactly by status quo of the land to be maintained?
status quo.
Whether they can do any construction or
They cannot change anything on the land.
Yes.
By creating this third party right after executing a plan, accepting the consideration. If they have not accepted the consideration, that's a different thing.
Then what effect it would have been on the land?
Yes, sir. After accepting the consideration, the third party right has been created. And if the third party right has been created, and if there is a stay order, a stay order is there, that amounts to the concept that is the Shah's order.
Yes, point out there what was the order.
So paragraph number 6.2.
Yes. You see that that is what the injunction said, restraining transfer or alienation of the suit property.
This is a transfer, third party transfer because they accept
That
the consideration.
the injunction there, it is not there anything like, it's only says status quo of the land in question. Where is the direction that is done by this?
Only a minute. If my lord see 2012 5 GLR 4148, paragraph 6.2, I just read point 1.
Wait. This is the same, no?
Yes. And
Yes.
this judgment relies on Supreme Court judge.
Yes, so first of all, let us see what was the injunction prayed for in Exhibit 5 application. It was restrain the defendants from transferring, alienating the suit land in question. This was the injunction. Thereafter, they entered into agreement to sell. Then the court held that that would definitely be breach of injunction.
चिट्ठी हमने
Page.
यहाँ पे भेजी, चिट्ठी
Para,
नंबर,
para.
पेज नंबर लिखो
I'm relying on
Page
2012 5 GLR 4148, para 6.2.
Yes.
Now, so far as the contention on behalf of the contesting respondent there, yes, sir, there is no breach of injunction as the contesting respondent defendant executed only an agreement to sale, which cannot be said to be a transfer.
Where this is a law well settled. Yes.
Just only 4 5 lines. In the bottom 2 lines. Okay, I'm
Yes.
not reading the 5 lines, I'm just reading 3 lines. But Rajnikant, Gulabai and another branch, the Honorable Supreme Court has specifically held that entering into an agreement to sale with respect to disputed property for which part of the consideration was also accepted is creation of a third party right.
Yes.
If there is a creation of a third party right, then there is a status quo order is breached. Sir.
No. Which order? Which order it says where the court has specifically under this injunction is passed under Exhibit 5, saying that they shall not create, alienate or create third party right, whatever.
Because the third
Amaj-
party right has been created.
Restrain.
The allegation of false, sir.
Therefore, in this case, there is no order similar to the injunction 5, which says that they are restricted from transferring, alienating the suit land.
Yes, sir.
Here it says status quo of the land till final disposal.
Status quo of the land.
Land.
Yes, sir. Status quo of the land. Once you transfer or alienate by way of this Banakar for reference, sir, the rights has been transferred and alienated.
Yes.
So the status quo order is breached. Status quo
Status-
means don't do with this land. Don't do. No create any third party right, no transfer, no construction, nothing as it is. Status quo means as it is on the date of the order, sir. Now by executing this Banakar and accepting the consideration. Once they accept the consideration, then third party right has been created. So it means a transfer
So
and
you,
alienation.
so your submission is that the direction issued in this court to maintain status quo of the land is to be construed as the directions of not transferring, alienating the suit land.
Status quo, it means status quo, you cannot do anything with the land. No transfer, no alienate, no construction, no create any kind of a right. No, you cannot change the nature of the land.
In this, the
You cannot
injunction,
change the nature of the land. By
yes,
by
nature of the
executing
land.
this, you are creating a third party right. You are changing the nature of the land.
If there is a direction, we incline to issue notice, don't worry. But if there is a direction similar to that which was in the present case, where the direction was not to alienate transfer this. There they have created a document which the court and the Supreme Court says, yes, this would amount to interference by third party right, hence these directions are violated.
Yes.
In your case, there is only two words, status quo of the land.
Status quo, again, I'm just repeating.
We understood.
So that's the only submission.
Notice it. Be ready for this
Yes,
next
yes, I
topic.
will be more ready on this.
Notice after 2 weeks.
And sir, they have written in the agreement that there is no mana income on this land, sir. That is, if my lord see,
You should have referred to this. My learned brother has pointed out.
that is also.
The number you have should have started from this.
Page 19.
Page 9, the statement.
mana income વેચાણ કરાર
नहीं,
કરેલો
ये
નથી કે
order
બાકાત
जे-
જ.
Page 9 no order. You should have directly pointed that. Second, third paragraph.
Yes.
He undertake it will not sold or transfer without permission. Hence that status quo was order passed.
Yes.
So आज
now
point
what's
out
for
करियो
that? I'm obliged to answer.
आप.
45 Mr. Jeet B. Karia. Sick note છે.
શું છે?
Sick note.
On 23rd March 23, this court passed the following order. Today it is reported that Learned Advocate Mr. G.P. Karia has filed a sick note. The matter is kept on Monday. If Learned Advocate Mr. Karia is desirous of filing any sick note on Monday, he shall make an alternate arrangement top of the court. તો આ કેવી રીતે આવી છે અહીં?
Pre નહીં હશે કદાચ.
ના આ તો છે જ નહીં. કન્ટેમ્પ ની નીચે તો છે જ નહીં. ના આ તો પેન્શન માંગે છે. ઓ અચ્છા ઓકે ઓકે સેમ ઓર્ડર.
Jail number 46 through jail.
પુત્રીની સગાઈ કરવા. It does not say. અને આની અંદર તો એના પુત્ર જ છે, પુત્રની સગાઈ, પુત્રની જ છે સગાઈ. હા હવે એક મિનિટ આમાં જોઈ લઈએ. જેલ વિકા
in October 2022 he was released. So minus one is verified how many
yes
child he has. It states that he has two male kids.
બંને છો, 2 sons, he is having 2 sons.
Yes. And he was once absconded for 42 days.
2022 thereafter
Thereafter,
he has been granted or not?
yes, in October 2000.
It's a 2 weeks. How much undergone? 7. 2 weeks.
Serial number 47, Mr. Siddharth R. Kheskani and Leonard DPP.
Successive application. Liberty was reserved to you after 1 year in 2019. After
Mhm.
3 years have passed, it is not.
How much sentence undergone?
Approximately 9.5 years, close to 10 years. We addressed a lot of the merits.
Yes, one merit only.
This is a matter under 302 minus that we conduct people like.
Mhm.
The brief facts of the case are that
Your criminal appeal is which? How many accused are there?
well, 2 accused are there, but this appeal has only 1 accused. The other co-accused is in another.
This one is 1080.
This is 1080.
Okay. What is the
There
role?
were 3 trials clubbed together. I was part of the first trial as accused number 1. Accused number 2, 3, and 4 have been acquitted. Accused number 5 has been convicted along with. Now the case rests on circumstantial evidence. The trial court itself has examined the entire case, said that it's a case of circumstantial evidence, although there is an eyewitness. It's a public incident where 4 rounds of bullets have been fired on the deceased. Pistol has been recovered after 1.5 years from the accused number 5. My role is that I was driving a bike and I pointed out to the deceased and the accused number 5 has fired. Now, there is no test identification admitted. The eyewitness on the food stall on which the deceased was standing while eating food and the firing happened has not identified. Neither does he say that there were some people on the bike. He says that 2 persons came and fired. He doesn't mention any bike. Neither does he identify. So he's not supporting the case of the prosecution in terms of the circumstantial evidence in its entirety or in part. That is my first submission. Further, my lords, let's take it further. This case also rests on some CDR reports and some call details. None of the SIM cards are in my name. There is no evidence to link that this number was used by me. That is one. Admittedly, if everything is to be believed, then the motive part, my lords, for me is nothing, because the rivalry between the 2 persons, the person who was killed had a rivalry with somebody known as Sanju Dev. Now, my lords, the person named Sonia was killed and Sanju Dev was the person who had plotted this killing. Admittedly, Sanju Dev is not examined, no statement. She is not an accused in this matter. I was a person taking care of Sanju Dev because she was in the hospital. That is the case of the prosecution. So admittedly, Sanju Dev goes out of the picture. There is no statement. So motive, personal motive, I don't have it. So the case falls on motive. Circumstantial evidence also, the trial court itself says 2, 3, and 4, there is no evidence. And the case is that all 5 of us sitting together had plotted this thing. So if 2, 3, and 4 are exonerated, the link itself breaks. Coupled with the fact that I have no motive, as I stated earlier. Now, my lords, what is more important in this matter is everything rests, my case against me, rests on this person known as Raju Dev. This is the square case against me. The person named Raju Dev has stated that Banavna 10 દિવસ પહેલા I had gone to meet him near Astoria. અને કુર્તામાંથી મેં એને પિસ્તલ બતાવેલી કે that I was supposed to kill the deceased. અને એના માટે મધ્યપ્રદેશથી એક માણસને બોલાવેલો છે. Prosecution's case is that I have gone there. Trial court has said his belief that there is no material that Shehzad had gone to Madhya Pradesh. One more link is taken out of the circumstantial evidence. Now this Raju Dev, my lords, has 7 antecedents. His first statement before the first investigating officer is on, my lords, I may just give the dates. The date of incident is 24/11/2011. In 24th November. The first statement of Raju Dev is 25/11/2011. No whisper. Second statement of Raju Dev before the second investigating officer is 10/12/2011. That is substantially after 15 days. Substantial improvement in those statements as well. Now after 5 days of the second statement, that is 15 December,
files an application before the magistrate to give a 164 statement. That is recorded in March 2012, 1st March 2012, that is after 4 months. This statement implicates me, not directly. He states that I had a motive and I had shown a pistol to him. Now the case of the prosecution is not that I fired, but this man, having 7 antecedents, also in his cross-examination admits that his statements are substantially improved. 1. 2, that he had given 2 separate statements to 2 separate investigating officers. 3, that he himself had some personal enmity with the deceased, and the deceased had filed 4 FIRs against him. So this man was supposed to be an accused, but he is converted into a witness. His statement is substantially recorded after 4 months before the magistrate. That is the only link against me. However, no material evidence got the name. So the Honorable Trial Court has mistaken and over-relied on Rajuddin's statement, who admits that he has personal enmity. 1. 2, that there was an FIR filed against him just 5-7 days prior to the date of incident. The enmity was such that 6 different police stations in Ahmedabad registered, offences were registered, and all from the Kinnar community, against the Kinnar community. Now, substantial cross-examination has happened, and all of these facts he has accepted. So Rajuddin's statement, according to me, should be disbelieved, and I may take my lord's.
Let us see the judgment where the conviction is. Yes, who is appearing? Are you ready? Mister, have you filed short synopsis as ordered by this court? You can give it directly if you have it.
I'm unable to look it, but I prepared it.
We'll keep it next week. Be ready or take instructions. Meanwhile, do the needful. Request of the day, APP, the matter is adjourned. 22nd of June. The other appeal of the other accused, when is it listed for hearing or?
No, my lords, it is not. No suspension of sentence is filed, and I believe, my lords,
You appear in that or someone
no, my
else?
lords, somebody else is appeared. And the last time I checked, my lords, he was released on some suspension of short temporary bail, and thereafter he has not surrendered. My lords. This man was staying in MP, the other accused.
The M. Karjun Ave. What is the number that also will also direct it to be listed? BG appeal છે. માં જોઈલે ને ઉપર જ છે. તો કોની ભાઈ? 10 કઈ છે?
1118 the 1118
બધી લિસ્ટ કરાવી દેજો નેક્સ્ટ એની સાથે જ આની સાથે જ.
તો with main matter કરાવો તો બંને આવી જાય.
હા with main matter કરાવી લે.
List with
along with main matter.
એવું લાગે.
See, he says that the other appellant is absconding or is not. Take instruction in that also. Take instruction in those others also.
No, इसको लिखा हुआ 1080 and 1118 of 70. 48 Mr. Mahesh P. Baria, Miss Megha M. Dave and Leonard F.
File a fresh application after 2 years.
Hmm.
The main my submission is present applicant is not more than 73 years old, and his health is too weak to be in jail. He is not able to have even a food in the jail. His health is too weak. He cannot live whole life if he is kept in jail.
Therefore, my
No,
request would be,
on the contrary, the food is so healthy, it will live longer.
because in jail below they don't give.
હા એકદમ સાદું ફૂડ છે, કોઈ કેલરી નહીં, કઈ નહીં,
એ ચાવી
ફેટ
દાંત
નહીં,
જ-
કઈ નહીં.
એના મોંમાં દાંત નથી છે.
તો વધારે લિક્વિડ જ લેશે,
Liquid આપતા નથી.
એમાં વધારે જીવે.
એટલે સાહેબ એની હેલ્થ બહુ ખરાબ છે અને મેરિટ ઉપર પહેલા 39 day once is permission was granted after you file a fresh petition after 2 years.
He has only undergone 4 years.
No, more than 4 years. I think his relative has informed him more than 7 years he has got.
No, 4 years and 9 months. This is the jail reform. And he has absconded for 824 days.
Twice he was granted temporary, then he surrendered himself. Page number
અરે ભાઈ 824 824 days.
Page number 13.
સવા એટલે 2 વર્ષ, almost 2 years to abscond રહે.
Recently he was entered on temporary bail below, but he surrendered himself below. He surrendered himself. He's too old to.
See, we'll go by the evidence instead of age. So convicted for life.
Exhibit.
તો મેઇન મેટર સાંભળી લઈએ હમણાં જ. Where is the order?
Paper book should page number 200. Deposition of your funds when they are relied upon is that exhibit.
Eyewitnesses are there.
No eyewitness. One witness is at turn hostile. He says the police forced them to sign the punch. They were not there.
We have to go by the evidence of IO.
Exhibit 4 and exhibit 6, 7.
Injured witness is there.
No, this is direct without any deposition.
Injured witness કહે છે ને કે અહીંયા પેલા
Nothing, sir. Just to share this.
આ ઈજા પામનાર બહેનની પૂછપરછ કરતા તેવું જણાવે કે તળાજા ગામની છું, તેમ સો મારેલ છે.
May I request, Lord, I will be permitted to produce the relevant depositions of the 3 witnesses, Lord, and 2 functional witnesses.
Exhibit 6 PW2 જરા વાંચો ને એની ટેસ્ટિમની. પેજ કયું? પેજ 71. મેઇન મેટર જ લિસ્ટ કરાવી દેજો ને, આપે લઈ લેશું. ઓલ્ડ એજ છે ને એટલે વહેલી ચલાવી દે. સિનિયર સિટીઝન કેટેગરી સારું છે, હમણાં જ ખબર પડી જાય આવતા અઠવાડિયે એને બહાર આવવાનું છે કે નથી. ટ્યુઝડે મૂકી દેજો વિથ મેઇન મેટર.
Next. Please.
20.
Please.
49 Mr. Vaibhav Vyas.
at 2:30 कर देजो. Tuesday 2:30. No passovers. It will not be called out if we say. Hmm. 10 years, 6 months. So you see, mainly because he has undergone 10 years, we are not supposed to release. So we have to examine on merits. If you convince us on merit, we'll release him. I don't think it will be called out. Next week move to this one. આને પણ main matter સાથે જ. You see all these matter which are we are directed in the main matter, so be prepared in that.
Serial number 50, Mr. Dhruv K. Dave and Leonard AGP.
For interim leave, this is a detention matter. What are the offenses? Where is the order? 307.
No, not 30. Page 15. Only two have been considered is the registered money lender.
30.
Completely confused section.
384 and
Yes, yes.
290. Yes, who appears? Allowed. CA not pressed.
Please, sir. Grateful, grateful.
Of really register कराई दे दो.
Main discourse, main rule if you can see.
Both are registered.
Hmm?
Main matter is also registered.
It is not notified. We will notify today itself.
Great, grateful.
51, Mr. Sachin D. Vasawada, Mr. M.I. Hawa, Mr. Chanakya Bhavsar.
Wait.
The additional affidavit was given
Where are the
in the month
directions?
of March.
Where are the directions?
The High Court's order,
It's of 2018.
page 50. That dismisses their AO and thereby not confirms the injunction. The injunction is on page 194. The order of the commercial court is page 194. The operative part is page 246.
No, where is the directions of this court?
Of the,
This judgment, which the direction which you are seeking compliance.
yes, sir.
Page.
Page 246. Correct. 246.
No, this is the order of where is the order of this court?
That's on page, it starts on page 25. And the operative part is on page 50.
Read that.
Yes, sir. Para 33. In view of the aforesaid, this court is of the view that for the reasons stated in the issue order as well as for the reasons recorded on this court, no interference is called for the issue order dated 3/9/2018, where exhibits 6 and 7 of the commercial trademark civil suit also also find that relief granted by the issue order is equitable and is balancing the respective rights of both the parties, hence no interference is called for. The abuse of order is dismissed.
So what was this order of 3rd September?
Exactly. So that is
These are directions that
page
become
27.
final.
Yes, it's incorporated in the final. Yes, page 27.
Yes.
I'm only reading the operative part, otherwise I need to read. 6
No,
or 7
only
pages.
only the operative part.
Yes. No, actually 246. 246 maybe.
246. This is this order was set aside.
No, confirm.
Sorry, confirm.
Confirm.
No intervention. Yes, this is the same order. Lead the directions.
There is, yes. The present notice of motion stands partly allows the defendants, their directors, partners, successors, servants, agents, leaders, and distributors hereby restrained from using the confidential information, know-how, technical knowledge, customized manufacturing machinery of the plaintiff mentioned in Annexure 8, produced at item number 8 with the list exhibit 4 to the final disposal of the suit. Now, this Annexure is page 60. It's a laundry list of all the items. The know-how, ex parte and integrity granted on 24/10/2016 in terms of para 35A according to that qualified and the rest of the it is made clear that the aforesaid order is not meant to preclude the defendants who otherwise are free to carry on their profession by utilizing their own skill and information mentally retained by them or by soliciting them independently. The rest of the relief sought for the plaintiffs are hereby disposed of without rest inclusive.
Then what they have done?
There is a question. Sorry.
What they have done?
Yes. So now that now please come to page 60. I just need to show around page 60. What is the next A?
60.
Yes, sir. This is the AHS, my client's portfolio, which is referred to by the commercial code in the operative paragraph. That this you can't use this.
No, Annexure A, this is Annexure A at page 60.
Yes, page 60.
So they were restrained from using
All
this.
this. Yes, sir. The product, the object is not the product group is mentioned and the dimensions are mentioned. The product name is mentioned. All this running up to 65.
Yes.
Now, what have they done? Now, please come to page 71.
Before my amendment can go to the details, I reiterate my request that I need a week's time to put in an affidavit.
We'll grant, but just we are first of all examining whether this contempt application itself is maintainable or not. This is something exercise we are undertaking in your favor. Yes.
Okay, no, otherwise, I'm going to argue, but this affidavit that of which they want to file a reply was given in the month of March. So there are 3 or 4 adjournments. I would request support not to grant, but whatever. Right? Ultimately, having said that, now please come to page 71.
Yes.
One by one, I'll show.
What is this?
Yes, this is software comparison between their Carbomix and my Paramix. Now, Paramix is in the annexure in that page 60. Now, if your lordship sees not, our case is that everything is copied. Please come to page 72. There is a code. The code is the same, page 72. But I'll show something more very, very crucial. Page 72. If required, we'll even highlight this. But most important, on this, it's the whole thing runs. Please come to page 75. That's very important. Because even if they say, will not say that, okay, they have their own code, it was mentally retained. But this is very important, because this can't be a coincidence. If your lordship at page 75, somewhere in the middle, mine is on the right hand side, it is on the left hand side. There is something in German. My parent company is German. These people, these Chinese clients, they were working for me for a long time. Your lordships had an occasion to deal with their quashing. And I will also go through the observations made by the court in their quashing. That quashing was rejected. I filed a complaint, police complaint, saying that they have, after leaving me, they have copied everything. They have taken away and they are doing the same thing. They are sending it to people and using my technical know-how, information. I filed a complaint.
there was a quashing done. Extensively, your lordships dealt with that in a 40-page judgment, where your lordships have virtually come to the conclusion that yes, this is a classic case of copy. Now here, important is that what I showed to your lordship, page 75, the German, you can have your own code, but you don't have a parent German company. You have your own company. It's an Indian company. Here, if your lordship see this, we can highlight this. This is German. Both mine is obviously German, but even the code, there is a German comment which is copied. That's also German. So this entire thing is copied. Now, more important, if your lordships come to after that, there is an expert report that we engage an expert's advice so that we could do a comparison. Now, if your lordships were to see important page 88, I'll read the expert's report afterwards. But please see page 88 of it. Because there is a comparison of 4. There are 4 people in this business. So I have given the details of 2 other competitors. What those 2 are doing and what you are doing. Now, if your lordships have, for example, bottle washer, the annexure, this is page 88. Now, Seidel is one. And Gebo Carmex is another. Lordships may see their drawings. Now, my client is KHS. The lordships may compare KHS with Rapid. KHS Rapid is the same. If the lordships want to see Seidel and Gebo Carmex, all these are different. Both are different. Now, one by one, ATA, then please see, this is bottle washer. The lordships will be able to see for all. Then bottle washers, bottle pocket, Seidel, Crohn's, different. KHS, Rapid, same. Then label extraction, Seidel, Crohn's, different. KHS, Rapid, same. Even the color is the same. Then mixer, SIPA, Crohn's, all these are the other 2 competitors. SIPA, Crohn's, different. KHS and Rapid, same. Then pasteurizer. Hemocarbex, Crohn's, Rapid, KHS, same. Conveyor, likewise, conveyor. Then equipment, bottle washer, all these. Page 94, lordships will see KHS is the bottom, and Rapid is on the left hand side. Bottom, same. All the drawings can be seen, everything is the same.
Now this direction which has been issued.
Yes. So they can, again, coming back to the direction, please come to page 60.
Page 246.
Yes, but
Restrained from using the confidential information, know-how, technical knowledge, customized manufacturing machinery. Now we have to say that this particular machinery is customized by you for manufacturing particular product. And this is not available in anywhere in the market.
Important, after your lordships read, know-how, technical knowledge mentioned in annexure A is important.
Yes, annexure A.
Annexure A is page 60.
Yes.
Simple. Page 60, for example, now please come to page 60. There is a paramix.
So you have to say that suppose page 60, one
All
item
these.
is there.
Oh, exactly. So that's what.
First is we'll go by product group, stretch, blow,
one by one.
molders,
So
KHS, so and so, size, so and so.
Yes, so to make it easy, if your lordships want to see.
See, first of all, in these matters,
yes,
can we impose our own wisdom whether in this technical know-how? So is there anything to say that
your lordships will have to. If it, again, I do understand that these are matters of science. I agree. There's no doubt. Because it's to understand technical know-how, because even the commercial court has obviously not gone into it. Your lordships in appeal also will have to go into it. Because whether this is know-how or not, all that will have to be, because when it comes to the court is the final arbiter. Here, your lordships are concerned with whether there is violation and whether there is copying of technical know-how, whether you have stolen my technical know-how.
this is annexure A, whatever annexure A was there.
Now, I can make out a case by showing what you are selling, what I am selling, and what is the code, what is the drawing, all that, because this ultimately is confidential. An argument has also been made that all this is in the public domain. That argument has been dealt with by the commercial court, and the commercial court has said that public domain or not, whatever it is, these are confidential information that you were privy to because you were working with these people, sent to Germany for training, and you came back, you worked for us, and then you left with all this. Now, in that background, Lord, if I'm able to convince the court,
You said that there is some expert report also which
that's
compares.
what I'm
all-
saying. Now, expert report will be important. Please come to. So I didn't want to. I was just showing the drawings, but please come to the expert report
Yes.
on page 76. I will have to read this now.
This is who? This is appointed by you or
Yes, Lord. Yes, Lord.
Department of
They
Mechanical?
also have done. It will be important. Lord. They also have done their expert. They have an expert, Lord, which therefore probably they want to file an affidavit. They have, as I understand, they have two experts. There is one person who they say is independent. Lord, that we have filed an additional affidavit and pointed out from Instagram or some photos, where Facebook, that he is a part of their team.
Then we'll appoint, the court will appoint independent expert.
Absolutely, we have no issues with that. They have taken two bites at the apple as far as this expert is concerned, and both we have discredited. One appears to be actually both. One Mr. Prabhu and Hon'Ble. Both are actually employees of the company. They have represented to this court that they are as if they are independent experts. But it turns out that we were able to get information from Facebook, and we have shown that we actually are employees of the company.
Now, this expert report at page 77.
Yes.
How did he prepare? Did he?
So he has given a. That's why I have to read.
Through documentary evidence or?
I have to read exactly what has he examined, background. He has given introduction, background information of the author. What is his degree? I read this.
You see, we intend to appoint an independent expert.
Yes.
And whatever cost, whatever.
Sir,
Yes.
even pay the cost. Even pay the cost.
But I would be able to demonstrate on the basis of the document.
You see, first of all, we are not the
And
experts.
this is order 39-2 is available, the evidence can be recorded. It's not a preliminary objection as such affecting maintainability, but this is a case where, and they keep filing it. This is filed in 2019. It is a small market, both of us manufacture conveyor belts, etc., with respect to bottling plants, which manufacture cans, beer cans and cans like Coca-Cola, etc. It's a small market where they are like there are agreements.
We are
all
only,
point out, sir.
we are only concerned with the directions.
Sir, I will.
He
I will
says-
point out, sir, then kindly have it up day after. I will point
We
out
will
that
give
why-
you that.
That why this court, why the honorable court also should not undertake that exercise. They have a remedy of 39-2A where I can, and this.
I don't have the
expert's
remedy.
evidence,
I am against the
that
High Court's order.
experts-
There is a
that-
question of 32.
that
Wait,
expert's
wait.
evidence on which my learned friend is putting so much reliance. Kindly
We will
see
not
page
go into,
87.
we are not
Sir,
examining
this
that.
is not a case where.
You see, against this expert evidence, we have also produced
We
our
have
expert.
produced it.
So when there is a
And sir,
conflict of expert opinions, we will direct the state to appoint.
sir, I would know what I'm saying, that here, this is a case that even that is not necessary.
Let's
Because
argue.
whenever-
Let me
Now,
argue.
this is a matter where after the filing this is filed in 29. After filing this contempt application, they have been writing letters to my rivals in the industry that don't buy from them. I have.
We are not
opened them.
concerned with
I'm
that.
not saying, I'm simply saying that sheer pendency of this petition has been working to their advantage. We have filed a suit restraining them from defamation that they should not undertake that letters. That suit was filed in May last year.
We are not concerned with
They are
that.
injuncted in Karnataka
I'm
also.
simply saying, sir, that's a
We
different
cannot
case.
venture except the directions.
I will, and
If
then
you can make out a case
I
that
will-
is contempt is not maintainable
make
and
out.
these directions,
are complete.
this is filed under which provision?
Contempt of court, sir.
That we are aware. Under which provision?
And read with contempt of court.
Section 10 and 11, subordinate code.
Sir, I am also, I'm
They are also
also,
injuncted in Karnataka.
sir, the order of the court itself, the order of the trial court, which is confirmed by this honorable court. That order, if my learned friend has as such read, but if your lordship sees the para 3 of the operating part, it very clearly says that the aforesaid order is not meant to preclude us from
doing or from manufacturing products on the basis of information which is mentally retained by us and which is available in the market. I have produced documents to show that this is not something which is confidential, that all this is available, their own machines are available in secondary
Their
market.
case,
They will fix it.
wait, their case is that annexure is what is the court has
Sir,
said.
I would-
You have violated that annexure
I
A
would be able to
particulars or
demonstrate that you
whatever.
have not. My request is that if your lordship keeps it next week, by that time I will complete the pleadings and will be ready to run the matter.
We prima facie, we are of the opinion that since this requires an opinion of an expert, we are going to appoint the expert.
Sir, we will, my attempt would be that even your lordship need not go there.
My
I
attempt
will-
would be because this is a fit case for actually not even doing that. Reading a chart.
Let
But
us
very
see.
well,
We
because I
are
read
on
from the,
board
I
for
read
it
from
to
the.
exist. I will be able to demonstrate.
Learned advocate Ms. Jani requests for some time in order to file affidavit in reply. The same shall be filed on or before the next date of hearing. The matter is kept on 25th of July.
No, I will not kindly direct them to file in advance, so that I don't think I see time. If they give it on 25th.
No, this is filing before us. They have to give in advance to you.
No, but if your lordship can record that they will file by so and so date, so that the matter.
We
can
have
be heard.
already said recorded, it will be filed on or before next date of hearing.
Before the hearing date, sir, they 1 કલાક.
અમારા માટે ફાઇલિંગ તમારે તો એડવાન્સમાં આપવું જ પડે. આ ઓર્ડર અમારા માટે.
No need to
A
record.
copy of which shall
If she is saying no need to record, no problem.
We will
Sir,
give
but
them
lordship
sufficient
may keep it
time
in
will
your-
be
it will not. We are kept in July only.
Sir,
July you want in July?
No, July 1st. So, sorry, 25th June, prepare.
એ તો રજા છે સન્ડે
26th, 27th June.
Okay. I do.
$52. Mr. Satish A. Pandya, Mr. Sharif A. Sheikh, Miss Archana U. Amin. My learned one.
Wait. Which one?
Order dated 15 March 2022 by the Chief Justice.
15 March, yes.
And the order is very clear. The order is-
Wait, let us.
Yes, sir.
So after this order, have they complied?
When here now. This
Who will remain present? Which is the authority? Which respondent?
But after this, the certain officers were present before the honorable court. The honorable court is now at length, and thereafter, Justice Anthony had dispensed with the sitting upon the assurance given by the learned ASG that as and when their presence will be required, they will remain present.
So we'll call now.
But our precise contention with the honorable court is that there is no contempt at all.
How? First order was passed directing and observing that there is a prima facie contempt since you have not complied with the directions of the limit single judge.
Thereafter, sir, thereafter,
So point out after this order dated 15 March 2022, you have passed some order.
We have, I know, sir, there is no such order passed by us.
That means you have not complied.
But sir, as such, the content itself is not maintainable for the reason that there was no direction of passing a fresh award so far as the applicants are concerned.
The court, have you challenged this order?
No, sir, since the view was from prima facie, sir, we argued on merits.
Earlier the court has already observed.
Prima facie view was.
So where is the directions? Directions of single judge. Which the court has found that it's a prima facie, they have committed contempt.
Is the order dated 29/2017, my lord?
Page.
Page 132 and 133, my lordship. 188. The lordship may take up the application. Another one is MC 188.
We are examining this first one. MC number 498 of 21. Which order you are seeking compliance?
The lordship is 188. I have everything. Okay, 150.
We have MCA number. Oh, number 498 of 21. Which direction? Yes, read.
The ultimate relief that we may grant would have to be bifurcated into parts. For those petitioners who have so far not accepted the compensation and have their challenge alive, and those who have already related accepted the compensation and also who the possessions of the land or other acquisition. For the former class, which we are informed, comprises of approximately 50 petitioners without disturbing the acquisition of the lands, we direct the competent authority to recompute and pass fresh orders in terms of the statutory provisions, which would include all statutory and incidental benefits, as if the declaration under subsection 1 of section 20A of the Act.
So this is not complied with?
No, not compliant with my lordship.
Read further. Read further.
Yes. Act is made on subsection 1. We are informed that these persons have already challenged the awards passed by the competent authority. Even after the fresh computation is provided herein above is done, they are not satisfied with the compensation that may become payable to them. It would be open for them to pursue the pending challenges before the arbitrator, who shall take the notice to further development in this regard. He did not give us anything. The award, so much date of acquisition notification shall be passed within
6 months from the date of the receipt of the order subject to cooperation from the concerned petitioners as well. The Railway Administration shall as soon as possible, after the award is passed, deposit the entire amount of compensation with the competent authority, who shall promptly pay over the same to the petitioner concerned. 29. For the later class of the petitioners, who have accepted the compensation which was offered to them much later, the Railway Administration shall pay interest from the date of the award of the competent authority till actual payment of the compensation at the compounded rate of 10% per annum. We are conscious that the rates currently prevailing interest rates are not that high. Nevertheless, we are persuaded to adopt a comparatively higher interest rate considering the gross delay.
These observations, the judgment has become final.
Yes, my lord.
Then after this,
After
what they
this,
did?
After this, lordship, we wrote letters to them that give an award, call us, reassess it. To no avail. After 5.5 years, my lordship, they are paying the same amount of the compensation that was awarded in 2014. The same exact amount. They did not comply with anything. They did not pay 10% interest. They did not reevaluate or re-award it. Nothing, my lord. And hence this contempt.
Yes.
And this was argued in detail. This,
What is page 142 order of Supreme Court?
we had gone to the Supreme Court, my lordship, but we did not entertain this order. They said is final.
No, it says there is some interim order granted 28/12/2000.
It was that stay, but it was not admitted in the Supreme Court. We had gone there.
Have they filed any affidavit in the present matter? So where is the compliance?
So in fact, my learned friend has read half of the facts of another matters in which the Honorable Court had directed us to pass a fresh award and
Pass fresh award in terms of the
pay the compensation accordingly. For that, may I request the Honorable Court to, my learned friend has read.
So means you have to only say that after this order of 22 September 2017, there is some order passed by you. Where is that?
We have passed fresh awards in case of matters of Kheda district, wherein the specific direction of the Honorable Court was to pass a fresh award. Factually, I may clarify.
This is a contempt on 12438, no?
Sir, the direction given in the present petitions are
Yes.
on page number 140.
Yes, 12438.
Yes, sir. We are concerned with this petition. Sir, paragraph 30, may I read, sir? At this stage, learned counsel with Hon'Ble borrowed for the petitioners in special civil application was also requested that the interim arrangement provided by the division bench of his Honorable Court under an order dated so and so may be continued till so and so to enable the petitioners to approach the Supreme Court. We notice that under the said order dated so and so passed in different civil applications filed by the petitioners in the respective petition, the division bench had provided for following interim arrangement. The respondent authorities are permitted to carry out survey only on two ends of the subject lands, and the same should be confined to 2 meters JCB width on each side. There should be at least damage should be done. The respondent authority.
Yes, but then that SLPs are now.
Sir, the precise challenge of the present applicant.
So you have to comply with the direction in paragraph 27 and 28.
So 27, 28 are the
29.
directions given in another matters of SCADA district.
There is no bifurcation.
Sir, it is clear. May I request the honorable court to have a look at page number 112, the facts of the petition filed by the present applicant.
Township receive 109, wherein
1,
all
2.
these matters are clubbed together.
Yes.
There is a question that this applies in
yes.
this matter or this does not apply.
Sir.
It's a common judgment, my lordship.
The common judgment directions are given in different matters because 3 matters were filed by the PAPs of Kheda district, filed by Mr. Amin, wherein the honorable court had directed us to pass fresh awards. We have passed fresh awards, we have paid the amount of compensation. So far as the petitions filed by the present applicants is concerned, in those petitions, we have challenged the section 20A notification as well as section 20E notification along
Now,
with the authority of the.
Paragraph 28 refers to some 18 petitioners. Are those
18
petitioners of this?
18 petitioners of the petitions filed by the PAPs of Kheda district.
In this, how many petitioners are there?
Lordship.
Yeah, more than.
My lordship has clarified 110.
5.
Lordship, 110.
Yes.
Number, paragraph 2.
Hmm.
This we may record basic test from the special 12438 of 2012. This 2012 is the basic that they have taken, and these 18 petitioners are being referred here is from this.
But then this contempt application, there are only 5. This application is filed by 5.
No, only 2 people.
5 applicants are there.
So far as 498 is concerned, there are 5. So far as 188 of 2021 is concerned, there are 2 applicants.
They are of, that is of special C 1244 of 9.
Yes.
So what about if you say these are the 18 of 12448, 124348? Then why only 5 have come?
No, so they only came to me as I do. The rest of them has not been paid as I have known. But these are
No. First of all, we'll by Ajara 12348 of 2012 ma petitioners કાઢ લો.
Which છે ને સાહેબ એના અંદર મારા પાસે આ મારા client
એટલે 5 જ છે ને, 18 તો નથી ને. તો પછી આ ડાયરેક્શન 18 માં આમાં ના હોય ને. 18% જે રેફર કર્યા છે, the person page 28 petitioners are referred, they are not of 12348.
No.
Then
This is what they are saying, not me.
this is what the court is observed in para 28.
Exactly, but then the basic facts which are taken, as I showed.
You see, maybe basic facts are taken. We have to see the ultimate directions issued in which matter. For others, they have already complied. For you,
No, they have not complied with anything. They are saying they complied only 18 out of all the petitioners here. All the petitioners.
point out the directions issued in 1, 2.
4, 3, 8.
That is the last paragraph. Last paragraph.
30.
Page 30, para 30. That only refers that Shri Dhaval Barot so and so requested that the interim arrangement provided by division under so and so may be continued till so and so to enable the petition to approach Supreme Court. So what was this? Was the interim direction which has been referred.
Right.
Now read those.
We continue till 10/11/2017 to enable the petitioner to approach the Supreme Court. We notice that under the same order dated 28/12/2016 was passed a different civil application filed by the petitioners in their respective petitions. The division bench had provided for the following interim arrangement. The authorities are permitted to carry out on 2 ends of the subject land. My lordship, these are how to acquire the land, and the same should be confined to 2 meters JCB. That is, they have acquired the land, and this is how the acquisition will take place. But as far as the direction is concerned, there are only 2. One, either you pay 10% interest or you reassess it. Here they neither pay 10% interest. Most of them, they are saying it applied only to 18 instead of all the petitioners.
So as per your case,
Yes,
your benefit which is ordered to be direct will fall in which paragraph? 28 or 29?
It will fall in 28. Because
29
they, because we did not accept the money. We challenged the order. And we also wrote a letter to them after this, stating that.
So,
to imply-
yes, now it says, read 28, para 28. The ultimate relief that we may grant would have bifurcated two parts.
Two parts.
For those petitioners who have so far not accepted, you have not accepted. The compensation and kept their challenge alive for those who have already, though belatedly, accept the compensation. So these are two classes you are forming in first class.
Exactly.
For the former class, that means you.
Yes.
Which we are informed comprises of approximately 18 petitioners. All the petitioners would, there are 5 or 6 petitions. So 18 would be all those of those petitioners who have not accepted and challenged. Without informed comprises so and so, without disturbing the acquisition of their lands, we direct the competent authority to compute and pass fresh award in terms of so and so.
Correct.
So have they passed any fresh award or not?
No, not at all.
Yes. They say that you have not passed fresh award.
Sir, paragraph 28 and 29 are with reference to the petitions mentioned in paragraph 27. I request the honorable court to have a look on page number 137, sir.
Read that.
Yes. The fact of the respondents have undoubtedly failed in making prompt payment of compensation to the petitioners of special civil application number 9571 and 9572 of 2013 is undisputable. We have noted that the awards were passed by the competent authority under section 28 of the Act. In such cases in August 2010 and 2011 respectively. The petitions were filed before the High Court in the year 2013. Till then, no compensation was paid. Much later, during the pendency of this petition, the compensation was offered to the petitioners on different dates. We are informed that some of the petitioners have accepted such compensation and handed over the possession of the lands to the government. Rest of the petitioners who did not accept such date.
So these are those who have not accepted. Special CA 9571, 972, 2013 are one who have accepted belatedly.
That is why the honorable court had bifurcated the relief in two
Exactly.
sides.
So first part is those who have challenged, they will fall in that.
No, sir.
Why?
There,
Point out that they have accepted it.
Sir, they have accepted belatedly, but the award, sir.
We'll record your statement.
Sir, that is why I am requesting the honorable court to.
No, we'll record a statement. Pay para 28 as per your say. There are two categories. Here they fall in second category in which they have accepted.
Fall in any of the categories
That can't be missed.
Sir, the award in the case of the present applicants was passed in the year 2014, not in 10 or 11.
That is why the court said to pass fresh order in those cases, those who have not accepted the amount.
Sir, by affidavit in deployment, I need to see.
Let us see.
Sir, before that, first of all.
So their entire exercise of filing writ petition is futile. They are nowhere. This is what you want to say.
Sir, they have, in fact, the challenge of the present applicants was the notification issued under section 28, saying that the railway board is not the central government. Railway board.
Forget about the merits. Para 28 points out two categories.
That is with reference to.
Now you say that they will not fall in any of these two categories.
That is with reference to the petition.
You say.
Sir,
We'll record it.
That is why we paragraph number 27.
Okay.
Sir, in.
Special MCA number 248 of
Sir, may I request this matter be kept.
498 of 21
Learned
on a
ASC
specific
represent,
query raised by
in
this
the-
court to learned advocate Ms. Amin, that whether the case of the petitioners or applicants will fall within the categories as suggested by the, as recorded by the division bench of this court in the judgment and order dated 21/22 September 2017. She has categorically replied that the applicants will not fall in either of the categories. One point next. In paragraph 28, the court has issued the following directions, 28 and 29. Full point. A bare perusal of the aforesaid direction would reveal that while granting the reliefs to the petitioners and issuing final directions, the division bench has categorically recorded that the petitioners have to be the relief claimed by the petitioners in group of petitioners have to be bifurcated into parts. One, for those petitioners who have so far not accepted the compensation and kept their challenge alive, and two, those who have already, though belatedly, accepted the compensation and also handed over the possession of their lands under acquisition. 4 point. Next, learned advocate Mr. So submitted that the case of the petitioner would fall in first category as they did not accept the compensation and had challenged. 4 point. Next, in the very same paragraph, the division bench has directed into inverted comma, we direct the competent authority to recompute and pass fresh award in terms of the statutory provision, which would include all statutory and incidental benefits as if the declaration under subsection into bracket 1 of section 20 capital A of the Act is made on 1st September 2017, comma, this direction has been ordered for the former class into bracket, that is the present petitioners or the claimants who have so far not accepted the compensation and kept their challenge alive, inverted comma over, full point. Next, the learned advocate Mr. So and so appearing for the applicants have asserted that after the aforesaid directions are issued, no award as directed by this court is passed, full point. Today, a stand is taken by the respondent authorities that the petitioner would neither fall in any of the categories and hence they are not entitled to any relief, full point. This argument is absolutely in contravention to the direction issued by this court as well as the observation made by the division bench, full point. Next, who will remain present?
Sir, may I request, for next week, learned ASC, sir. Sir,
This is only between the contemner and the court.
Sir, I understand, sir, but sir.
So point out to Mr. Who is the
Sir, may I
authority?
request to have a look at page number 112, the facts of the present, the petitions filed by the.
This is your statement made. We have recorded. Now explain that
Sir, my
statement.
statement is that para 28 and 29 refers to para 27. So far.
So we'll say, Miss Amin has further submitted that aforesaid direction or observation will only confine to the petitioners of special CN number 9571 and 9572 of 2013 as reflected in para 27.
Sir, we have already passed fresh awards so far as those petitions are concerned. We have, sir, my humble request to the honorable.
This is what you
Sir,
are.
this matter next week, let the learned ASC be here. That is,
This
sir,
is
my
with,
humble
now the
request.
contemner has to explain it,
Sir,
and we'll keep him present.
Sir, I understand.
We'll
that,
directly
but-
have a dialogue with
Sir,
him
Sir,
that whether the petitioners, after obtaining the orders
sir, that is why
and
I-
making so much efforts after division bench, you say they are neither here nor there.
Sir, that is why I started with saying that learned AS is representing the authority kindly.
So
inform
point
us.
out who has to remain present, or we'll issue non-bailable warrant.
Affect my practice. Otherwise, I would not have requested so much.
Which is the authority?
Sir, this may be kept on Monday or Monday.
We'll keep it on Monday, but I will ask them to remain present.
Dedicated.
Sir, special civil papers of special civil applications may kindly be called for.
No,
because-
we cannot
Sir,
examine
in
the
one-
merits.
In one matter, there are more than 71 petitions.
We are
In
not
another
going,
matter,
we are not examining contempt matters. We have to see the directions, whether they are complied or
Sir,
not.
that is why my request to the honorable court is to simply adjourn the matter, let learned.
No,
ASG be
absolutely
here.
not. They are waiting since how many years?
Sir, let learned ASG be
And
here.
after the order passed by the division bench.
Sir,
So you would like to ignore the division bench directions and thereafter the direction issued by the contempt bench.
no, sir.
This is how your authorities are treating the directions,
Kindly
as if the courts are whiling away the time and they have filed a futile litigation.
That is not the case.
This is what they are thinking.
Sir, kindly consider.
So we like to clarify, you,
Sir,
this
kindly
Ministry of Railway,
There are dedicated freight corridor, these are the offices.
no, that give the specific name. Shivraj Singh Gilwa. Mister, you have to give the names. What about the authority? You have not given names. It can't be in this manner, mister. You have to give the name who has committed contempt.
It is the deputy collector, my lord.
What is his
Shivraj
name?
Singh Gilwa,
What is that?
collector office.
Collector office would be the.
The award is supposed to be passed by whom?
Collector.
Collector, no?
Authority Special Land Acquisition.
Remain. Ask him.
So, Melons, we have filed affidavit in reply stating that in special civil application 12449, Melons, they have sought only alignment.
12438.
One.
This is under for 12438.
All the three matters. They have sought only the prayers with regard to alignment, Melons. It was tagged together with the.
We are saying about 12348.
Yes, Melons. 1, 2, 3, 4.
12438.
Many matters were filed.
Award were required to pass by definitely by special land acquisition officer, deputy collector, Melons. But Melons, all the process is required to be done by the railway authorities. Melons,
So you give the name that this officer is required to do such.
One moment. 12438, 12449, 12444. All three matters were tagged with 1570, 1571, and 9572, 9571, and 9570. These three matters and other three matters, Melons, all are with regard to the same project, and that is how this three and this three were tagged together, Melons. In one Melons matter, there was an issue with regard to the compensation, and they were not satisfied with the compensation. And Melons, in another matter, another set of matter, there was issue with regard to the alignment. Melons.
Exactly.
Yes, Melons. But in matter.
So those five matters in which they have not accepted compensation, the court directed to file fresh award. Have you filed? Have you passed fresh award in that case?
In matter starts with 9570, 9571.
In this 912438 in name of
But there is direction with regard to alignment, Melons. It was rejected by the Hon'Ble division bench, Melons, and that is how the direction in paragraph number 13, Melons.
we'll see. A special say 12438. Now, do you have the memo of the petition? 12438.
I have filed affidavit.
No, we'll go by them. We'll see the contents of affidavit. 230 continue. अब 12438 जो મળે તો મંગાઈ લેજો. 2012 ની છે 19 માં ડિસ્પોઝલ. મેમો તો નથી. Special say 1234 12438 main matter. Continue at 230. Meanwhile, come with the name of the officers. I'll come with the name of the It can't be in this manner, mister. You have to give the name who has committed contempt.
It is the deputy collector, my lord.
What is his
Shivraj
name?
Singh Gilwa, collector office.
The award is supposed to be passed by whom?
Collector.
Collector, no?
Authority Special Land Acquisition.
Remain. Ask him.
So, Melons, we have filed affidavit in reply stating that in special civil application 12449. Well, they have sought only alignment.
12438.
One.
This is under for 12438.
All the three matters. They have sought only the prayers with regard to alignment. It was tagged together with the.
We are saying about 12348.
Yes, 1234.
12438.
Many matters were filed. Award was required to pass by definitely by special land acquisition officer, deputy collector, madam. But madam, all the processes required to be done by the railway authorities. Madam,
So you give the name that this officer is required to do such.
one moment. 12438, 12449, 12444. All three matters were tagged with 1570, 1571, and 9572, 9571, and 9570. These three matters and other three matters, well, it's all are with regard to the same project, and that is how there was an issue with regard to the compensation, and they were not satisfied with the compensation. And well, in another matter, another set of matter, there was issue with regard to the alignment. Madam.
Exactly.
Yes, madam. But in matter.
So those five matters in which they have not accepted
Yes,
compensation, the court directed to file fresh
Yes,
award.
madam. That
Have you
is-
filed?
that is-
Have you
that
passed
is
fresh
my-
award in their
Yes,
case?
madam. In matter starts with 9570, 9571.
In this 912438 in name of
But madam, there is direction with regard to alignment, madam. It was rejected by the honorable division bench, madam, and that is how the direction in paragraph number 13, madam.
we'll see. A special say 12438. Now, do you have the memo of the petition? 12438.
I have filed affidavit.
No, we'll go by the, we'll see the contents of affidavit. 230 continue. अब 12438 जो મળે તો મંગાઈ લેજો. 2012 ની છે 19 માં ડિસ્પોઝલ. મેમો તો નથી. Special say 1234 12438 main matter. Continue at 230. Meanwhile, come with the name of the officers.
Yes.
Yes. Yes. Adjourn. Yes.
And then the petitioner was found suffering from cancer and other side were related. Registered FIR, so direct service we could not serve upon the respondents. Only payer losses may issue notice and direct service to RPAD or speed post.
For 5 and 7 is no. Baki 1, 2, 4 they are solved.
Yes, so only for private persons.
Who is the one who has to comply?
In fact, it's a government authority.
So we let it be called out.
I will not press at this stage because the petition is pending. So I can
Okay. Not pressed at this stage. Serial number 5015. Not pressed at this stage. Matter of.
Here the military in between said the person is the same person.
Granted, what's the good name? Love Modi for petitioner. We share that appearing for the petition has submitted that the petitioner has passed away on 29th April 23 and he would like to file appropriate application for bringing a legal heirs on record. On his request, the matter is kept on 31st July. Not 31st, sorry. 4th of July. Which one? 80? Yes. Today or as per our convenience. Will adjourn. On the request of non-adequate Mr. Jay Shah, serial number 86. Matter is adjourned on 6th of July.
Today's partner matter serial number 52. Mr. Sharif A. Sheikh, Ms. Archana Yomin, and Leonard A.
Look at the prayers of so prayer is they are seeking, questioning and setting aside of land acquisition process. Questioning and land acquisition by issuing notification 6 February 2012. That is also challenged. Main prayer has to be seen. If they have pressed the alternative prayer, then only the main prayer is setting aside 6 to 2012. And they have further said
if management values page number 106 of the present content application.
yes.
It is paragraph number 2.4.
No, it is not there. Yes.
Paragraph number 2.4.
Hmm.
In the stage, the petition was filed in which the petitioners had challenged the same notification dated 6/2012, proposing the acquired land and order dated 12/6/2012, under which the 28/1/2030 under section 20E of the Railways Act, declaring that land mentioned in the schedule to notification would rest absolutely in government, free from all encumbrance, which included the land of preservation. The petitioner therefore, with the leave of the court, amended the petition to challenge the state subsequent notification also. These facts are common in special civil application number 22. Thereafter, further in 2.5. In special civil application number so and so of 2013, the petitioner has challenged similar acquisition proceedings of the respondent undertaken for the same project. The distinct being that this land situated in different area. In this petition, the question of amending the previous acquisition by the railway and changing the alignment of proposed corridor is not involved. In other words, this petition do not raise a question of any factual or legal malafide in the railway authority changing the alignment under which the land came up for acquisition. However, this petitions raise identical other question of law. The fact is.
So there are two groups. As per now, come to page 126, where the court has refused to interfere with the alignment process. Now, after this finding, the challenge to the notification, whereby the court finally, in paragraph 28, alienated two bifurcated two groups. So you want to say that if its alternate prayer is rejected, he is not entitled to benefits of the first prayer, main prayers.
May request matters to read the paragraph number 28 because matters paragraph number 27 is required to be read before paragraph number 28 because it is in continuance with paragraph number 20. It is in furtherance with paragraph number 20.
Yes, so you want to say that their petition which they have filed was a futile exercise in the court had directed not to interfere with the alignment.
Yes.
So there is main prayer of setting aside that notification and everything. Okay, so you want to say that notification which that already remained.
Yes, of course, even if minus may start with paragraph number 27 and then read paragraph number 28, it would make sense to manage even paragraph number 28.
Yes, that is what we have recorded.
Yes, but then there is no, if minus may read paragraph number 27 first and thereafter the paragraph number.
We have already read that. 27 pertains to three petitions.
Yes,
After that, page 28.
Paragraph number 27.
So where is the directions of the division bench saying that special C number so and so is rejected? Point out.
It is mentioned that it is disposed of, and that is how they have requested for further interim relief, which were extended matters so that they can challenge because.
So they were disposed of in what terms? That their alignment issue is not interfered with. So what will happen to the main prayer of challenge of the proceedings of 6 February 2012? Yes, read that.
And this is London Council for petitioner in special application number 7 requested that interim arrangement provided by division bench for this court under order 28/12/2016 may continue till 10/11/2017 be unable the petitioner to approach the Supreme Court. We notice that under the same order dated 28/12/2016 passed in different civil application filed by the petitioner in their respective petitions, the division bench had provided for the following interim arrangement. The arrangement shall continue till 10/11/2017.
Yes.
In special civil application number 1, petitions are disposed of accordingly. Whereas these applications were disposed of, the court might not have specifically said that they are dismissed, but court had not interfered in issue of alignment.
Yes, but that is what we are saying now. Forget about issue of alignment. That was the alternate prayer. That is rejected. Main prayer would still remain.
Yes, but there is no observation with regard to the main prayer also. But
So let us see whether this notification dated 6 February 2012, which they sought quashing, and also notification dated 28 February 2013, where they have stated to issue so and so, quashing and setting a land proceeding so and so. So two notifications they have challenged, 6 February and 28 February 2013. Where is that observation? Yes.
The Honorable Court has given the specific reasons in paragraph 13.
Yes.
13 page for 127.
Yes. Yes.
The first thing of the contention of the council for the petitions was that such notifications were issued by the railway board and not the Ministry of Railways, and therefore not valid. In this context, as pointed out by the respondents, the acting solution of suffering such activity, the President of India is paying rules for allocation of business for the government of India, in which the Minister of Railways is allocated the subject pertaining to government railways and non-government railways. As inducted in the schedule to the Railways Act, the Ministry of Railways conveys this decision to the authorized officer. It is further pointed out that the Minister of Railways was thus acting through the Railway Board. The President of India institutional powers under the
Come to para 23.
Yes.
We are unable, page 135, we are unable to accept the contention of the petitioner that for want of proper diligence, so and so level interact, so this contention is rejected.
Yes. After the this refers to the shifting of the.
Yes. Now para 24.
Yes, para 24, coming to the question of delaying payment, that is the delaying payment is concerned, that is in matters of Kheda district, that is 9570, 9571 and 72.
Yes.
Because during the pendency of those petitions, the amount were offered to the PAPs of those petitions and some of them were accepted.
So what have you done in those petitions?
Sir, the persons who had accepted the amount of compensation pending those petitions, they were given 10% interest as directed by the Honorable Court. And the persons who had not accepted the amount and continued with the challenge for those PAPs, a fresh award was passed considering the date of notification as on it is issued in the year 2017, and fresh award as per the provisions of the right to fair compensation.
So, as per your say, they will fall in which category, whether they have accepted the compensation or not.
The PAPs, that is project affected parties of Kheda district are concerned, half of them, some of them had accepted pending petitions, so they were given 10% interest as directed by the Honorable. Some of them had not accepted the compensation.
And they had challenged it. They are also
They
the.
continued with the challenge.
Yes.
At the end, after the argument, it was considered before the Honorable Court that they are not challenging the land acquisition per se, but they are very much interested in getting the compensation at higher rate. So the court found out the buyer media and directed us to pay interest to the person who had accepted delayed payment and to pass a fresh award in case of those persons.
Those are not before us.
No, those are not.
We are only concerned the categories of the claimants who challenge, who filed petitions for further challenging.
Yes, so far as the present applicants
Ultimately, their petitions are rejected or whatever.
that is why SLP was filed.
SLP also, that is also
After
rejected.
that, they filed another petition before this Honorable Court seeking the same relief that were given in the case of PAPs of Kheda. That petition they came to be withdrawn with the liberty to file contempt proceedings in the year 2020. And after that, this contempt application.
So where they will go? Today, they are those categories of persons who have not accepted that fall in the first category. So are you are not supposed to pass fresh award in terms of section 20A?
For the present applicants. Yes.
Then
Sir, in the case of the present applicants, the awards were passed in the year 2014. The Honorable Court has referred the awards passed in the year 2010 and 11. Here the awards were passed in 2014. When the amount was accepted, that is, I am not aware about as of now. But the award is passed on different, in different year.
Whatever treatment you have given to other persons who fall in the first category is required to be extended to them in view of the subsequent event that their challenge to that further challenge has failed. Court has also observed what was the division bench was conscious about that fact that yes, they have challenged, but let their challenge proceed. However, you have to pass fresh award.
Sir, that is, yes, I do accept, but that is, sir, with respect to the PAPs of KEDA, we have complied with the direction. There is no.
Where is the bifurcation? Did you seek any clarification from the division bench that you are supposed to only comply with KEDA and this person?
Honestly speaking, I was not there. I came in picture only when this contempt application.
So we don't know that where is the predicament in passing the same award which has been passed in other petitions.
The reason is that after disposing of the petitions filed by the present applicants, they approached the Honorable Supreme Court challenging the.
Now that has gone.
The challenging the dismissal of their petitions.
Yes.
That was not entertained by the Honorable Apex Court. Thereafter, they availed the remedy of filing petitions seeking the same review.
That has gone. There the court has already reserved the liberty to file contempt proceedings. Now today, everything is gone before this.
They are seeking compliance of the judgment which was passed in 2017. Wherein the Honorable Division Bench has granted certain relief to the PAPs of KEDA which have been duly complied with.
So comply in the deal also. Why are you not complying?
No such direction so far as the present because if the Honorable Court.
We will clarify that. That it is your misreading of the judgment. Not a single line from the judgment you have pointed out that these are the petition of 1, 2, 4, C and so are not entitled to any relief since their challenge before the Supreme Court is pending.
That is why, sir, I was requesting, I am still requesting if this can be cleared on Monday or.
Yes, Monday definitely, but someone would remain to act. We have already clarified.
That may already passed on Monday. That is my.
Absolutely not.
That is my humble request.
This is after the first direction issue that all these aspects were considered by the coordinate bench while passing the order of 15th March 2022. 1 year has passed.
Sir, kindly give me one opportunity to us to convince your lordship that there is no content.
We have observed that prima facie it is there.
That is why my request, the repeated request to Honorable Court to kindly simply adjourn the matter on Monday.
We'll ask some officer to remain present and we'll take it. We would like to see that how he is interpreting this orders. You are incorporating something where there is which is not observed by the division bench. Either you should have sought clarification that this judgment will not apply to the direction will not apply in main jurisdiction 1, 2, so and so, the present one. Hence they are not entitled. Nothing is gone.
Simply adjourn the matter on Monday. Let us again go through the same. Let the.
We have already applied the mind. Thrice we have adjourned.
Still thinks that there is a contempt, clear contempt. Then let the officer be ordered to be.
That is why we are ordering. Yes, Monday will remain present.
No, sir, Monday it will be that order will be passed on. Sir, 4, I am requesting only for 4 days, nothing more than that.
Monday, the officer which will remain present for framing of the charge.
May I point out one thing? It is additional prayer in the data matters which was pointed out in the observation of the judgment matters. It is on page number 113. That is how it was reading paragraph number 2.5 matters.
113.
Yes, madam.
Yes.
Additionally, they also have raised issue of non-payment and delayed payment of compensation.
Yes.
And that is how those observations in paragraph number 27.
Yes.
That is how I was reading that additionally they have also raised the issue of non-payment.
Read 3 lines above that. However, these petitions raise identical other question of law facts in other group of petitions.
Yes, madam.
So law and the issue which is similar.
Similar, which is with regard to the notification. Additional to that, non-payment or delay payment.
So we are not concerned with that issue because they are not claiming it. They are the persons who have.
Yes, additional to that, this Kheda district.
You are supposed to pass a fresh award as per the direction. In their cases, those who have challenged it.
What I'm submitting before this honorable court is the petitioners of 9570, 9571 and 9572 has raised issue before this honorable court that they have issues with regard to payment. And that is how does the direction in paragraph number 27, 28 and 29 with regard to the payment that whoever has not accepted.
That is not their case. They want a fresh award in terms of paragraph 28 for those petitioners who have sought to challenge for this action further. Ultimately, they have failed. Either you should have sought the clarification from that, otherwise the directions are very clear. There are two sets of petitioners which are by. You cannot just cut and read it isolation. Para 2.5 only applies to 3 petitions, whereas the other petition there is no relief. So their entire filing of this petition itself is without any purpose. There were two alternate prayers. One challenge of so and so. Second one was of alternate prayer that the court did not find in favor of them. Ultimately, the notification of which on the ground which they challenged that also did not. After hearing them, all the group of petition, the coordinate bench, the division bench, divided two as this bifurcated the petition into two categories. As per they say, they fall in one category who sought to challenge the action further. In those cases, direction is issued that you pass fresh order as per section 20. For which you have already complied in some Kheda district, and you refuse to comply in the case. So why don't you pass fresh awards in this also? Only because there is no direction. Then the court was conscious of the fact that about their challenge. In the very beginning, it was observed that the amended prayer was allowed, and thereafter subsequent notification is also challenged. So 3 petitions, 6 petitions are divided. And ultimately, in para 20, they have the court had bifurcated that these are the petitioners who have challenged and these are the petitioners who seek compensation and interest. So you want to partly comply in Kheda district, forget about the other 3 petitions. How can that be done? Or point out the reason that why you are not doing it. You are not doing it only because you say that there is no direction and no prayer.
In paragraph number 27 specifically the court has directed to comply us, directed us to comply with regard to 957.
Where is that? That is your misreading. Or point out a single line that this relief which is claimed by them is absolutely rejected, and whatever happens before the Supreme Court, that will be final, or they will be bound by that. It is not the word used is disposed of, it is not dismissed. Monday. I would request of the matter is kept on Monday, Tuesday. बाकी बड़ी special चीज़ नहीं पहली जो ठीक है ना order in chose in paper मंगाए registry shall place the papers of special CA number so and so, so and so, so and so. Now we clarify that if you are able to convince us, then it will not be problematic. We will reject this. But from the averments in the writ petition, we find out that in other 2 petitions there is such case. Then be ready for the exemplary cost over and above the contempt proceedings. Monday. Tuesday.
Recall daily board serial number daily board 1 serial number 9 Miss Jayashree Sipat.
Yes. Where is the order? Allowed.
Twenty-two Mr. M.S. Padalia.
Vice President of Hon'Ble District for non-participation. If any restoration application.
Purport board serial number 2 Mr. R.J. Goswami, Mr. C.B. Upadhyay.
The party's name is both of them are present.
Never leave to amend him and make him as a party. The pursuant to the order dated 12 June 23. So and so officers have personally remained present before this court. Learned Advocate Mr. Upadhyay has tendered the undertaking dated 13 June 23. A copy of which is supplied to Learned Advocate Mr. What's a good name? So and so for Mr. R.J. Goswami. The same is ordered to be taken on record. Full point. As per the amendments made in the undertaking, comma, a check to the tune of his 5 lakh. Have you come with the check? Is it there? Is handed over to hand over to him. Is handed over to Learned Advocate Mr. So and so, so and so. The matter is kept for further hearing on 23rd of June. It is only you can file further affidavit, whatever you want to say. So if you want to say anything, file, we'll consider on the next date of hearing. Meanwhile, whatever you want to deal with that, today accept 5 lakh rupees. 23rd? 22nd? No, 22nd. So then 20th, 20. 20.
For court serial number 4, part in person, Miss Shabana Banu.
Oh.
Daily board serial number 16, Mr. Vishal P. Thakkar. बेसो बेन थोड़ी बात
Which my lord should give a couple of days when I copy the hard copy, but in the meantime, I've got this one judgment, my lord, which takes care of the issue. Not take much time, my lord, the head notes. A and B are relevant, my lord.
Yes.
Very much. Content Contempt of Court Act 1971, Section 13 and 2B. Civil Procedure Code, Order 22, Rule 3, Contempt of Court Act 1971, Section 2B and 30. Consent decree passed by courts on basis of terms agreed to parties. The parties of degree is contempt of court, but it is direct discretion of the court to initiate contempt proceedings. Contention with contempt would not lie as being executable under the Civil Procedure Code. Contention not tenable. Ultimately, the matter is one of the court's discretion having regard to the facts of the case and the two citations. The second element is important. Contempt of court at 1971, Section 30 and 2. Violation of decrees and orders of court. Whether accounts of consent are whether amounts to contempt, yes. All decrees and orders, including consent decrees, are executable in the Civil Procedure Code, but merely because an order or decree is executable would not take away the court's jurisdiction to deal with a matter under the Contempt of Court Act. Provided the court is satisfied the violation of the order or decree itself.
Yes.
That is true. It would warrant punishment under Section 13 of the Act on the ground that the contempt substantially interferes or tends substantially to interfere with the due course of justice. Now, my lord, paragraph 26 in the judgment, my lord,
Yes.
is also on the same line. Paragraph 26, my lord, it's a small paragraph. All decrees and orders are executable under the Civil Procedure Code. Consent decrees or orders are of course also executable, but merely because an order or decree is executable would not take away the court's jurisdiction to deal with the matter under the Act, provided the court is satisfied that the violation of the order or decree is such that if proved, it would warrant to punishment under Section 13 of the Act on the ground that the contempt substantially interferes or tends substantially to interfere with the due course of justice. The decision relied upon by the respondents themselves holds so, as we shall subsequently see. Now, my lord, the last paragraph, that is paragraph 36, 37, and 38, that is discussed the same issue, my lord. Paragraph 36. Having regard to the fact of the case that court felt that the contempt proceeding should not have been restored to and that in any case, since the unconditional apology has been tendered and accepted by the appellant, further proceeding should not have been dropped. As we read the decision, its ratio runs counter to the submissions of the respondents, namely that the contempt would not lie if the decree or order is executable. Ultimately, the matter is one of the court's discretion having regard to the facts of the case, as we have said that the fact that the decree is executable does not take away court's jurisdiction in contempt. In the present case, the consent terms arrived at between the parties were incorporated in the order passed by the courts on 12 December 2001 and 8 January 2001. The decree that is drawn up shows that the order dated 8 January 2002 was to be punctually observed and carried into execution by all concerned. A violation of the terms of the consent order would amount to a violation of the court's order dated 12 December 2001 and 8 January 2001. Therefore, be punishable under the first claim of Section 2B of the Contempt of Court.
And પેલી અગાઉ 95 વાળી છે ને એ પણ. Yes, anything else?
At 95, my lords, is directly he has approached before this honorable court for execution of the order of the learned labor court. Over here, my lords, when this honorable court has passed an order, so in that case, my lords, the order of labor court and order of this honorable court gets merged, my lords. So that 95 would not apply to this present case, my lords. There is one decision of this honorable court wherein, my lords, that 95 order has been taken care by this honorable court, my lords, in the case of Murji, that is of 2000.
Yes.
2003 and 5329 something, my lords. On that, this honorable court.
Cite, give the cite.
In a minute, my lords. I do have the soft copy, so my lords, I'm requesting to go over in the first half,
No.
my lords, because.
Give the citation.
I
Give the party's name.
2001 LLJ 409. Urjibai Gudabai versus Upendra Vyas, manager reported in 2001 LLJ 409.
Yes.
So that has taken care of the 95 judgment, 95 to GLS.
Wait, give the party's name.
Murjibai Gurabai versus Upendra Vyas, manager reported in 2001 LLJ 409.
Supreme Court or this court?
This court. Relying on the Alhar judgment of 1995, which my lord just said, the three judgments. Murjibai Gurabai. That I had brought, my lords, in the previous one matter. I had got those judgments, my lords. If it on the first, in the top of the board, if my lord sees it tomorrow, I get all the judgments.
No, we have got it. Don't worry.
Murjibai Gurabai. Wherein they have relied on the 1995 decision of the Honorable Electric Court of the three judges. 95 to 550 has been taken care of, my lord. Now, my lords, after that in 2006, there was one more decision wherein this.
The Murjibai says that contempt is not maintainable.
Then, my lord, in 2006, my lord, this honorable court
Give the citation, whatever you want to. एक अलग है जो मूर्जी भाई बुरा भाई वर्सेस उपेंद्र व्यास मैनेजर that is relied upon.
Another citation is 2001.
Wait 2000 volume 3 GLR 2339 reline करो. Yes, another one.
Other one is 2001 IILLJ.
What is the party's name?
It is Jai Singh Jodhabai Vaishya.
Jai Singh
Jodhabai Vaishya. When he has held that Murjibai per inquiry.
Jai Singh.
Jai Singh by Jai Singh, JAISINH, Jodhabai Vaishya.
आपण लखी लेजो 2001 GLH volume 268. Yes, anything else?
So my lords, what will happen is, my lords, 15 years he has fought before the labor court. He won there. With back wages also he has won, my lord, reinstatement in continuity of service. That order was challenged before this honorable court. Wherein after 10 years of fighting over here in this honorable court, my lord, he has again won the same order. Now, my lords, when the same is to be executed, my lord, till now, my lords, this honorable
चलो
court
बीजो
always-
citation आप मैं आपके 96 और
95 or 95.
ये पेज बताओ ना.
मैं जे आप ये 96 2 GL 812 GLR છે 96 1 GLR sorry 1 GLR 812 812
So what will happen is that 15 years before the labor court, 10 over here again. And my lord, once he files recovery application, my lord, is just like the.
you see we have to see law our order will become a precedent so we don't want to entertain.
That 95 my lord has been taken care in the 2000 judgment. That 2000 judgment has been held per inquiry of 2001.
We deal with all your contention, don't
This,
worry.
my lord, this judgment which I just recently produced is 2006 judgment of 3 judge benches of honorable.
That we'll deal with it. We'll deal
They
with
have
it.
stated, my lords.
Yes, yes, once you have read,
The
no
last
need to,
paragraph, my lords.
no need to repeat, we'll deal with it. No, no, we are rejecting, it is not mentally.
What will he have to again wait for 10 years before the.
That cannot be, it's a law, if it is law, we have to follow it.
This Industrial dispute act, my lord, is a beneficial legislation, my lord. Again, he will have to fight for 10 years. Till the time he is in that condition to have that recovery order, my lord, that recovery certificate. Again, for the recovery certificate execution, he'll have to knock the doors of this honorable court.
You have to follow the Supreme Court judgment.
But my lord, this is the later one.
We'll deal with it.
Please, my lord.
CPC will discuss corruption. MCA number.
Only for a while, my lords, one more. Because then I just provided the Jai Singh wala case. Only I will purpose read paragraph 16 for at least for a while, my lords.
Yes, read.
16, may I remind my lords? There are 16 of Jai Singh cases. I do not have the hard copy.
Yes.
May I read, my lords?
एक मिनट 2001 volume 2 GLH page 68 आपण Yes. What are the facts of the case?
It was regarding the contempt of court filed against the order of the labor court.
Yes.
Wherein only paragraph 16 takes care of the complaint. That 15 also is the
There is no para 50.
I have a soft copy wherein my lords 15 and 16.
What does it start from?
It starts from 16 starts from we have no doubt in our mind.
Yes, read that.
We have no doubt in our mind that if the above decision of Honorable the Supreme Court in Income Tax Appellate Tribunal case rendered it on November 17, 1998 was brought to the notice of the High Court in Gurjibai Burabai's case, there would have remained no occasion for the bench to take a view that the
Which Supreme Court decision?
The Appellate Tribunal's judgment, my lords.
Which? Yes, read further.
We have no doubt in our mind that if the above decision of Honorable the Supreme Court in Income Tax Appellate Tribunal case rendered on November 17, 1998 was brought to the notice of High Court in Gurjibai Burabai's case, there would have remained no occasion for the bench to take a view that the proceedings of breach of award made by Labour Court or Industry Tribunal are not maintainable under the Contempt of Court Act. Which view runs contrary to the ratio of the decision of the Supreme Court in Income Tax Appellate Tribunal case. That a court of record has inherent powers to punish for contempt of all courts and tribunals subordinate to it in order to protect that least subordinate courts are tribunals and tribunals. The decision in Gurjibai Burabai's case, to an extent, it runs counter the ratio of the decision of the Supreme Court in Income Tax Appellate Tribunal case, cannot be treated as a binding precedent because it has been rendered without noticing that the same decision of the Supreme Court and it would be a per inquirium decision. It has been held by the Supreme Court in Commissioner of Hindu Religious and Endowments.
Now, what about the? Let us see this appellate tribunal's case.
It is 1999.
1999 volume 1 SCC page 16 आप
99 1 SCC 16.
Yes.
I do not have the copy. Page 16 it is, sir.
It was suo moto proceedings. So how that will help?
Also, it has been discussed that all the courts and tribunals are subordinate, my lords.
Yes, so they will come under section 10. But then here the tribunal under the ID Act is already empowered for taking up execution proceedings and implementing of the award.
My lords, it is a discretionary power of the court. If the court is satisfied that there is
If there were a direction in the present matter that award is to be complied within so and so period, you would have a case.
My lord, that has remained, my lord. But once the order of the Honorable Court is passed, my lords, the order of learned labor court merges with the order of the Honorable.
Man, there has to be subsequent directions
But then, my lords, only what has been stated is that
that their petition is dismissed.
sir, dismissed when they dismiss it, when it found that there is no substance in the matter, my lords. It has
Yes.
dismissed it.
What about this judgment of Alar, 3 judges bench of Supreme Court?
That is of 1995.
Yes. How that
Alar
division
judgment,
bench
my
is.
lords, that is directly the labor court order, my lords, was brought in contempt.
So in this division bench of Jai Singh Jodha, point out that 95 is ignored or it is considered and thereafter it has been distinguished.
I think Jodhabai, my lord, starts with this order only.
Yes, it starts with that order.
Starts with Mojibai Burabai.
Yes, but that it considers this judgment of Alar Cooperative
Also,
Services.
The learned council also relied upon the decision of the Supreme Court in Allah Cooperative.
Yes.
In which the Honorable Supreme Court observed the labor court was not a court subordinate to the High Court in the sense, but that is in 2000, my lords. 2000. Then, my lords, the Honorable Apex Court in judgments have stated that the labor court and ministerial courts are.
This judgment of Supreme Court on Alar, whether it is overruled or not.
But my lords, in this Jai Singh case, my lords, it has
Yes.
taken care of Mojibai also and Alar also.
We are going by 3 judges bench on Alar case. How it is distinguished.
Alar, my lords, was directly the labor court orders or the award of labor
So
court. was
point
directly
out,
in contempt.
so point out that this Alar is distinguished.
The learned council also relied upon the decision of the Supreme Court in Alar Cooperative Court in so and so, in which the Honorable Supreme Court observed the labor court was not a court subordinate to the High Court in sense of the contents of court and made provision requiring the High Court to deal with contempt of its subordinate courts and has struck off the contempt proceeding before the High Court.
So
So, my lord, my lord, my request for tomorrow in the top of the board, my lord, I can distinguish this also.
we'll read with this that how the division bench either has to follow the directions issued by the Supreme Court or in alternative it has to distinguish that it is not applicable in so and so facts. We do not see in this judgment.
For that, this judgment will come to my rescue. There is
Which
only request.
that will not apply.
But this will squarely apply. because
That
my-
will, you say, but you say it's your contention, we'll deal with it. It will not
What has happened
apply.
is, my lord, this order, my
We are
lord-
not here to convince you.
No,
It will not
I
apply.
request, I'm trying to convince.
So
you.
we'll see, we have already considered, so that
Only-
judgment is
only thing
apart.
My lords, if at all my lords are passing, the Alhar order, my lords, was the labor court order which was directly brought before this honorable court for contempt of court. Now, this judgment, my lords, is labor court, then this honorable court, and then contempt.
Which judgment?
This one. my
So point out that it can be done in that manner. Where is that observation?
lord. But then, my lord, this gives a supervisory jurisdiction to this honorable court to initiate contempt of court.
Then what every,
Alhar has stated, my lords. Alhar
that
has-
is why if there would have been directions that yes, after petition, give the benefits of this award within period specific time, then you had a case.
That small line, as I have listed in all the judgments,
Then-
my lords, all the orders of this honorable court in the last.
Then you could have filed MC or application that is permissible for fixing the time limit for compliance.
Then my lord, the permit with that. Or my lords may give me time till tomorrow morning, I can distinguish Alhar also, my lords. If at all, I can convince my lords.
No, you had time to 2:30, you had time. In the morning, it was kept on your request at 2:30. So we'll read, we have enough time, we'll read the entire judgment. Start from paragraph 1.
Alhar,
Yes, Allah.
Alhar is a small one page.
આપો ને એમને કોપી આપો 2001-2 આપી આપી દો પેજ 68 આપી દો એમને. Read from para 1.
Jai Singh case, my lords.
Yes, Jai Singh case.
Para 1. In these two petitions, the learned counsel appearing by the opponents have taken up a preliminary objection against initiation of contempt proceedings of the effect of the labor court and ministerial tribunals are not courts subordinate to the high court. And hence contempt proceedings are upon non-compliance of any order or award of the labor court or ministerial tribunal they are not maintainable. They have placed reliance on the decision of Murjibai Burabai versus Upendra as reported in Coalition, in which it was held that the though labor court industry have trappings an attribute of a court and they were amenable to writ jurisdiction of the High Court, they were not courts as contemplated under the Contempt of Court Act 1971. And therefore proceedings for breach of any order or award made by such courts and tribunals
are not maintainable under the provisions of the Act. The learned counsel also relied upon the decision of the Supreme Court in Aadhaar Cooperative Credit Society versus Shamla report in so and so, in which the Honorable Supreme Court had observed that the Labour Court was not a court subordinate to the High Court in the sense that the Contempt of Court Act makes a provision requiring the High Court to deal with contempt to its subordinate courts and has struck off the contempt proceeding before the High Court. The division bench in Morjibhai Burabhai's case followed the decision in Aadhaar Cooperative Credit Service Society case and held that the Labour courts and judicial were not courts within the meaning of Section 10 of the Contempt of Court Act. It was held that even in the Labour court performed judicial functions and the presiding officer formed part of judicial services and the judges of the Labour Court and Industrial Tribunal belong to the judicial service of the state, that will not make the Labour Court and the tribunal a court. And as to attract the provisions of Section 10 of the Contempt of Court Act, it was further held that merely because High Court exercises powers under Article 227 of the Constitution of India over the Labour Court, as contemplated by the said Act, it was observed that if that reason is accepted, the forums constituted under the Central and Local Act shall have to be declared as courts. It has been contended that the decision of Supreme Court in Aadhaar Cooperative Society's case was directly on the point dealing with the precise issue as to whether the Labour Court was a court subordinate to the High Court for the purpose of initiating proceedings under the Contempt of Court Act, and therefore the decision was binding on this court and has been rightly followed by the division bench of this court. It was submitted that if a different view is thought of, then the matter ought to be referred to a larger bench of the court. The learned counsel for the respondents in support of the submissions placed on reliance on, also on the following decisions. State of AP was relied upon to contend that the matter should be referred to a larger bench if a view from the one taken in Morjibhai's case is likely to be taken. From para 10 of the judgment, it would be noticed that it was contended before the Supreme Court that since the judgment of this learned single judge in petitions filed by SAS accountants has been affirmed in the appeal earlier by the division bench, the other division bench could not have dismissed the petitions and set aside the judgments of this learned single judge. And in context to the contention of the Supreme Court said that if the second division bench was of the opinion that it had to be to take a different view than the taken, then that taken by the first division bench in matter should, as a matter propriety, have been referred to a larger bench. Mahanagar Railway Vendors Union, reported in so and so, was cited for the proposition that the decision of a larger bench of 3 judges of Supreme Court would prevail over the decision of the bench of 2 judges. The learned senior counsel and the counsel who argued for the applicant seeking initiation of the contempt proceeding contended it was the settled legal position that Labour Court and Industrial are courts subordinate to High Court, and that in any event contempt jurisdiction could be invoked for breach of any order or award made by the subordinate court or tribunal. The learned counsel placed reliance on the following decision support of the contention. Thakur Jugal Kishore, reporting so and so, was cited for the proposition that subordination for the purpose of Section 3 of the Contempt of Court Act means judicial subordination, and the assistant registrar functioning under the Bihar and Odisha Cooperative Society Act was a court subordinate to the High Court for the purpose of Section 3 of the same Act. The decision of Supreme Court in S.K. Sarkar, reporting so and so, was cited for the proposition of the phrase court subordinate to it and used in Section 10 of the Contempt of Court Act, and it was wide enough to include all courts which are judicially subordinate to the High Court. It was held that the Court of Revenue Board is a court subordinate to High Court within the contemplation of Section 10 of the Act. Delhi Judicial Service versus so and so, reported in 1999 and so and so. It was relied upon for the proposition that the High Court as a court of record and inherent powers to indict the person for the contempt of itself, as well as the court's inferior to it. And the Section 10 of the said Act, like Section 3 of the Act of 1952, reiterates and reaffirms the jurisdiction of the power of the High Court with respect to its own contempt and the subordinate courts. A full bench decision of the court in Gujarat Mazdoor Sabha so and so, reported in 1998 so and so, was relied upon to point out that on the basis of the decision of Supreme Court in case of Maharashtra, because of the it was already held that the terms court will cover all tribunals and basically courts performing judicial functions. The decision of Supreme Court in Durga Sarikar versus so and so, reported in 1994 so and so, was cited for the proposition that the expression tribunal as used in Article 136 of the Constitutional one includes within its ambit all adjudicating bodies considered by the state and invested with judicial functions. Prantiya Kamdar Sena and other report in 98 so and so was referred with a view to point out that division bench after noticing that Alhar Cooperative Credit Society's case, the Supreme Court has held that effect of the labor court was not a court subordinate to the High Court and not forming part of the judicial service of the state, held that it was only in the decision given the Supreme Court on 11/2/1998 in state of Maharashtra versus Labor Practice Association that matter was elaborately dealt with by the Supreme Court, and it was held that the labor courts and industrial courts would come in the preview of state judicial services. Head of UP Synthetics and so and so was cited to show that Supreme Court in paragraph 14 and 41 of judgment has held that the effect of the doctrine of per incurium and sep silentio operate and as expectations to the rule of precedent, and that a decision not expressed nor founded or reasons for proceeding on consideration for the issue cannot be deemed to be law declared under the Article 1(4) of the Constitution. Under Article 2(1) of the Constitution of India, it has been provided that every High Court shall be court of record and shall have all powers of such a court, including the power of to punish for contempt of itself. Under Section 10 of the Contempt of Court Act 1980, it is iteratively provided that every High Court shall have and exercise the same jurisdiction powers and authority in accordance with the same procedure and practice in respect to contempts of court act subordinate to it, and it has and exercises in respect to the contempt of itself.
Point out in the entire judgment, the division bench has a single line as dealt with this judgment of 95. Only in the first paragraph it is referred. Thereafter, there is no mention about that.
In that case, I would request my lords for tomorrow morning on top of the board. I'll try to
Finish it. We have already finished this judgment.
I leave it to my lord because my lord, what will happen is my lord, this honorable court, my lord, and the honorable apex court in the judgment that I provided, my lord, that has stated that High Court has supervisory powers of all the courts under it, and High Court can initiate, my lord, the contempt of court proceeding. So, my lord, the 95 judgment was direct. If at all we take for sake of believing, if we take that the order of labor court was not direct before this honorable court and directly they have initiated contempt proceedings, which in fact, my lord, still now, in various decisions, my lord, the honorable court has taken care of it. But my lords, in the present case, my lords, what has happened is that order has been challenged before this honorable court, substantially heard, my lords, and this honorable court has squarely dismissed their application, my lords. So the order of labor court has merged with this honorable court's order, meaning thereby, my lords, that this order now belongs to this honorable court. So, my lords, this High Court, my lords, has the power to initiate contempt of court proceedings.
IMCA number 450 of 23. We have heard the learned advocate Mr. So and so at length. The present application is filed seeking following press 11ABC. Next, as the prayers would suggest, the applicant is seeking for initiation of proceedings of contempt of Courts Act 1971 against the respondents and to punish them for committing civil contempt. Full point. Prayer B suggests that the petitioner has prayed for a declaration that the order passed by this court in caption read petition be operated and executed. Any acts of the respondent may not confer right in favor of the present applicant in any manner whatsoever. Full point. Next. Thus, the petitioner has prayed for initiation of contempt of proceedings under contempt of Court Act 1971, and further The order passed by this court dated 15th February 23 in caption read petition may be executed. At this stage, it would be apposite to incorporate the directions issued by the learned signal judge in the order dated 15th February 23, passed in special CA number 11670/2014. The same reads as under para 10. Next. The final observations while dismissing the writ petition reveal that the learned single judge has dismissed the writ petition against the challenge of the judgment and award passed by the Labour Court, Bhavnagar. The state authorities had assailed the award and order passed by the Labour Court in reference LCB number 91 of 2008, dated 11th April 2014. Full point. Next. On a specific query raised by this court with regard to the petition, the applicant having any alternative remedy of execution of the award, common learned advocate Mr. So-and-so has placed reliance on the judgment of the Supreme Court in case of Ram Narang versus Ramesh Narang and others reported in (2006) Volume 1 Criminal Application .R into bracket Supreme Court page 475, and also the division bench judgment. Can you tell me? Of this court in the case of Jai Singh Jodha by Vaisya versus Lakshman by Arshi by Jala, reported in 2001, volume 2, GLH, page 68. Full point. Learned advocate Mr. Johnson submitted that this is the award which was challenged by the state authorities has merged with the order passed by the court and the petition dismissed. The award dated so and so is required to be executed and benefit thereof is required to be paid to the petitioner. Full point. Next. By placing reliance on the decision of the division bench in case of Jai Singh Jodha by Vaisya. Supra. પેલું આખું નામ શું છે? એક મિનિટ. Comma, it is submitted that the respondents have committed contempt in not extending the benefits arising of the award dated April 2014 after the writ petition has been dismissed. Learned advocate Mr. So-and-so, while referring to the contents or observations made by the Supreme Court in the case of Ram Narang, more particularly para 26, has submitted that since the Supreme Court has already held that all decrees and orders are executed executable under the Civil Procedure Code, including consent decrees or orders, comma, and merely because of such execution of such orders and decrees, comma, the same would not take away the court's jurisdiction to deal with the matters under the Contempt of Courts Act. Next. Similarly, by placing reliance on the judgment of Division Bench of the Court of in case of Judging Doda by West Chasova, it is contended that we can consider નથી કર્યું એવું છે 3 જજ ઇન્કમ ટેક્સ એપોલેટમાં તો લોચામાં એક્સપ્રેસ એગ્રી કોર્ટ એમાં કોઈ વધારે so and so larger bench than we are referring the matter to larger bench. Full point next. We are confronted with the observation made by the division bench in case of Jai Singh Jodha by Vaisya, wherein the division bench, after considering the judgment of the Supreme Court in case of appellate આમાં તો છે જ નહીં. Income tax appellate tribunal versus V.K. Agarwal and other report in 1999, volume 1, SEC page 16. Has held that as under para 8 later. Next. It is noticed by us that the applicant before the division bench had also practically placed reliance on the judgment of the Supreme Court in case of Alar Cooperative Credit Service Society versus Shamlal, reported in 1995, volume 2, GLH 550. In support of his case that the contempt application would not be maintainable in view of the aforesaid judgment. Full point. Next, we have considered the judgment of the division bench in case of Jai Singh Jodha by Vaisya and Grofed Employees Union, reported in 2001, volume 2, GLH page 68. Wherein the division bench has held the one decision of the division bench in case of Murjibhai Burabai versus Upendra Vyas, that is reported in 2000, volume 2, GLS 768. as per inquirium in view of the decision of the Supreme Court in case of Income Tax Appellate Tribunal Supra. આપણે આને જો ઓલ્ડ પર ઇન્ક્લુઝન કરાય તો પેલા કન્સિડર એનું ડીલ જ નથી આને કીધું જ છે મૂળજી વાળું મૂળજી ભાઈ ક્યાં ગયું 2000 volume 2 GLS 768. तो जो तो सबसे बड़ी कंसीडर करें कई तारीख को सुप्रीम कोर्ट कंसीडर करेंगे रेफर करेंगे Sheikh Mohammed Suanshi overlay. IGA. Good. GSC goes up. Supreme Court में लगे तो GLR Supreme Court We'll keep it tomorrow. We have to wrap whether this alert is subsequently considered or not. Kale rakho. If subsequently
there is no time period given to comply with the order. There was never a stay when the writ petition was pending, so therefore my learned friend could have filed a petition as soon as the
It was being paid as per 17G.
in some cases. And my lord,
today we are only seeing about the maintainability of the application. You are right. Then there is no direction. Nothing is there.
in this particular case, there is no contempt notice issued to us, my lord.
It is not issued.
Representations are there. They have also replied to it.
Yes.
16 for representation. Is representation of the workman. 17
આમાં લખ્યું છે પેરા 2 ગુજરાત હાઈકોર્ટ અને આમદારનું અનાદર કરી આપની કે મને આજ દિન સુધી પૂર્ણ સ્થાપિત નથી કર્યું આવું છે 16 માં એને લખ્યું જ છે આપની અરજી આપની સહી કરી ચકાસણી કરવા આવે છે પૂરતા કરવા જણાવે છે શક્તિઓ માલુમ પડે ધ્યાન પર મોકલી આપે પછી 18
તો એ લોકોએ કીધું ડેટ તમે બદલી દો અને સાઇન કરો. They have done that.
The language will have to be seen on it.
એને કર્યું છે ને અનાદર કરી આપે so and so law says that you have to he has to invite the attention that you have done thereafter something further is done in page 18 what is that
Page 18 is the same thing. Madam. They have on 17 they have said you have not mentioned the date. The date mentioned is wrong. You have not signed. I give them again with new date and sign.
what is the date of this
18/3/2020.
It must have been then first. Something further would have happened.
He is visiting from failures to post, my lord. He went to Gandhinagar also in the Sachivalaya, my lord, for getting the orders complied, my lord. But still no reply.
That is why the execution proceedings you have to file. Yes.
Also, my lord, that judgment which I tendered yesterday, that if no specific time is given to comply with the order, the Karnataka High Court judgment which considers the Supreme Court judgment, then the contempt won't be maintainable.
Yes, we are ready on this also. Note down the package. AR 1984 Supreme Court 1264. 1264. So what we had suggested earlier, that in this you will get a clue from this. You have to file an application to Supreme Court side for fixing the time limit for compliance.
Probably, my lord, if the time limit is not fixed, it will not wash away the order.
That is what Supreme Court has said so.
I go through this.
It has said that.
Also, Pallav statement.
Pallav Shet also go through. This year Supreme Court has observed. If no time limit, no contempt.
Tomorrow, day after tomorrow.
Day after tomorrow. No, tomorrow.
Day after tomorrow, I'll
Bench is not available.
then my lord, the day for the
You see, we have applied so much.
That is why, my lord, if at all I'm not able to bring one or two more judgments, my lord, I'll get 2 days, I'll work hard for one person, my lord. It is
Monday.
not only for this one person, my lord. Many
Monday.
workmen, my lord, who are in the same.
Meanwhile, inquire that what is the status. You must have got something. Must have been done.
Nothing.
Inquire tomorrow.
Already. I have to call in the morning.
Monday.
Please, hurry up.
We intend to refer. Prima facie, if that alert is subsequently dealt by the Supreme Court, then you will not refer. On the contrary, we will declare this division bench judgment as per inquiry in view of Allah. The same thing with the division bench has done to the earlier decision.
But then, my lord,
Murji bhai.
that also takes care of Allah.
Mr. This will not. This is specifically an undertaking in a criminal matter with regard to the custody and something, and they are the
Order is order.
not order in the civil code. Civil code, when there is a specific, that is what in subsequent division bench it is held. It is executable if any consent decree or undertaking is passed. Here in 95, the court has specifically dealt under section 7 of the ID Act. The tribunal has power to execute it. So 3 judges alert, if subsequently done, you have no case.
I'll do this. Please, hurry up.
Monday. Simple as well.
Serial number 43, Mr. Vaibhav Vyas.
Yes. Same. What is that?
Order of the authority was already washed and satisfied, and the further direction was with regard to that the same shall be treated as non-existent for the benefits, if any, the petitioner is entitled to during service tenure henceforth. That is the only direction which was required to be complied with. I have taken instruction from my officer, but that is the only promotion which is subsequent benefit which he is going to get.
Page 18, read your statement.
Yes, madam, I have gone to
So?
FC 125 of 2000.
So where is the order?
Yes, madam. Promotion, madam, thereafter they have preferred latest better topic matters, which is coming up on 16th, 2020.
Tomorrow, lagos, MCA number
Well, it's in a moment, madam.
894 or 23. The
Only one request, madam.
RK Bagora, OS DGP office, Gandhinagar, as well as the who would be the one or two who has to pass the orders.
May I request, may I submit this list? I have put it to the highest officer of the department, matters. Home department is required to be matters done to the needful matters. The promotion is required to be considered. Promotion process is required to be done, matters. For that purpose, matters, the process has already started, matters. So for that matters, some time is required to be done. DPC is required to be convened, matters. For that purpose, matters, I'm requesting some accommodation. Matters, I'll be.
We'll record all your submissions.
But matters, here here I know that we are matters in contempt matters. I'm not. pressing
Contempt of first order, contempt of second order, duping the court, cheating, playing fraud on this court.
Benefit is promotion, that is what we understand, and my lords, for that purpose, it is matter of my lords, scrutiny, my lords.
We'll
and
consider
that is-
all the things. Look,
But my lords,
learned AGP on instruct, who has instructed you?
my lords, Mr. Koda is.
Give the designation. I submitted that. The benefit of promotion and the, sorry, is required to be conferred to the petitioner after undertaking a process which will require further time. She has submitted that accordingly. The direction issued by this court as of today, though, are not complied. Comma, are you willing to comply?
Yes,
Will be complied. Full point. LPS filed.
yes, my lords.
She has submitted the letters patent appeal. What is the number?
632 of 2020.
632 of 2023 is challenging the judgment and order dated 10th March 2022 is already filed. What has happened?
It is pending, my lords.
The same is pending. Notice is issued.
No, my lords, it is, delay has been found.
In which delay is only gone down. Full point. Anything else? No. In the present application, the application, the applicant, original petitioner, has sought following reliefs. A. Next. By the order dated 10th March 2022, passed in the caption repetition being special CA number 14473 of 21. This court had set aside the order penalty dated 15th April 21 and had directed that the same shall be treated as non-existence for the benefits, if any, which the petitioner is entitled during his service tenure. Thereafter, the petitioner filed MCA number 12523 for initiation of contempt proceedings, since no benefits were given to the petitioner. By the order dated 6th April 23, by reposing faith in the officer Shri R.K. Bhagora OS, DGP Office, Gandhinagar, the division bench of this court disposed of the contempt application with the order dated 6th April 23 by observing thus. Para 1 and 2. Next. It is very shocking to note that despite an undertaking and assurance given to this court, the directions issued by this court with the order dated 10th March 2022 were not complied. Hence, the petitioner is compelled to file the present contempt application. Today, when the matter is taken up, learned AGP has made the aforementioned submissions. Thus, there is blatant disregard to the direction issued by this court, as well as by making the statement which is recorded in the order dated 6th April 23, the respondent authorities has tried to mislead this court and was successful enough to dispose of the contempt application. Full point. Leave to amend R.K. Bhagora OS DGP Office, Gandhinagar as party respond number 3. Full point. The all the three respondents, Shri Mukesh Puri, comma 2, Shri Vikas Sai, and 3, R.K. Bhagora, shall personally remain present before this court tomorrow at 11 a.m. so that the court may frame the charges against them. Full point ऊपर notice करीने कर जो. Direct service permitted today. Learned AGP is directed.
I may find affidavit before 5 o'clock matters that it may be complied with within a week matters before matters subject to outcome of LPA matters. Matters cannot pass this order.
Come with 5 o'clock, before 5 o'clock. We will be still imposing 25,000 rupees cost on each of them. भाई पहला हमने leave to amend पहला हमने party बना लो आप.
Matters as such, only one thing I want to submit. As such, there was order of only एक हक्का नहीं सजाती, which matters they have already matters it was caution set aside by the Hon'Ble court, and ultimately subsequently there was no nothing personally to this petitioner matters. It was just the promotion which they have already initiated matters the process. It was, I understand matters that the promotion is yet to be granted matters which has not been done matters, but ultimately that is the only benefit and nothing else. I am not aware that what they have sought in the present petition matters.
We are not, you see, we are only saying when you made a statement before this court to pass order within 6 weeks.
Yes,
Have you done it?
no matters, promotion has not been granted, but the process of promotion, if the promotion is it is considered as benefit, then matters it would take its
That is
own
why the
matters.
petition was filed, because on this, that penalty order, he could not have been denied the any service benefits because already set aside. That is why the direction was given that all the further benefits may be granted.
So matters, it's just that it was not intended by the officer, because even the DGP office was.
Why did you make a statement before this court that you are going to comply within 6 weeks? Once having made a statement, that means you have played fraud on this court.
That could not be the, I will.
No, that is the intention.
I will come to the.
You wanted to see avoid the contempt proceedings by making such statement. That officer, Mr. whoever he is, he made a statement
Yes.
that you are going to comply, and the court, by placing reliance upon your statement, faith in you, disposed of the contempt application.
I understand. matters.
So,
Would not have been.
so you took the court on ride. That is the, you see,
I will file an affidavit of unconditional apology to my lords and the explanation also that in what circumstances this.
you
has
see,
been
we'll
done
issue, we'd like to see that they remain present at 5 o'clock before this court. That person should remain. Leave to amend.
I,
The, or we will ask the concerned police officer to arrest him and produce before this court. Leave to amend.
he is not-
Mr. He can come from
Yes,
anywhere,
yes,
out
sir,
of
I-
India also.
He is not here. Tomorrow I will ask him to be here. Matters may not pass that order.
Where he is?
He's
He's in the state of, I
he is
inquire
in
right
the
now.
state. Matters-
Inquire which, from where? We'll sit again at 7 o'clock.
He is at Navsari. I'll request
Navsari
him
કેટલું
to go
distance
at-
આવે કેટલો કલાક છે?
3 કલાક 4 કલાક.
We'll assemble at 10:30.
Tomorrow at 11.
10:30 we'll assemble. Mr. R.K. Bhagora, OS DGP office is presently ઉપરનું order એમને જ રહેવા દેજો. Posted at, give the designation, where is,
Here
which
only
office?
he's on leave, matters, and that is how.
We can arrange.
Matters, he is at Gujarat. And I'll get the address. He's at Gujarat.
Give the will, concerned police station will order his arrest.
Matters, tomorrow 11 o'clock, he will be here. I assure that he will be here, and the affidavit I'll tender at 5 o'clock. I'll get it done, and matters at 5 o'clock I'll.
We want where he is residing now, so can the concerned police station will direct them to arrest him and produce him today.
I will come with the.
We'll sit at, આપણે 12 વાગે we have no objection, we'll sit again. This is how you have duped the court. You have played fraud on the court. Do you think that we'll give just put an end to the proceedings?
No, Milos may anyway pass appropriate order after explanation, receiving the explanation from him also.
You see, there cannot be any explanation.
Only once Milos the opportunity of.
Period of 6 weeks from today, he has said that relying upon such oral assurance recorded in the order, Mr. Vyas so and so does not press this petition.
I am very well aware, Milos. I have gone through the order, Milos. That is how I am requesting this honorable court.
Clear case of contempt. The charge is already, we will frame it right now and we'll order his arrest. He should be behind bars.
Only till tomorrow, 11 o'clock, he will be here. I assure this honorable court that he will be here with an explanation. If Milos are not satisfied with the explanation, he will in hand of Milos and Milos may pass.
Do you intend to comply with the order? Give that also.
Yes, Milos. That application.
Learned AGP
affidavit will be from the.
has submitted that. The officer R.K. Bhagora, OSDG Office, Gandhinagar, who has made statement before this court and recorded in the order dated 6th April 23, will remain present before this court tomorrow at 11. Kale Mukhi. This is how you dupe the courts. You know. This will not end here. Leave to amend. Respond number 3, Mr. R.K. Bhagora as party respondent. Just also make him inform that be ready for the consequences tomorrow. Order Rajesh सही कराएगा.
Court continues serial number 54. Mr. Apurva Kapadia and Mr. Manish J. Patel.
There is some development today itself. When the OPA was there, we got the coordinated and the one MCA, which is here the learned single, as the statement draw the attention of the honorable court. The direction issued by the learned single. According to the court's directive, such as the sheet of the petition, for entitlement to the regular case for the petition particular project from their original date of appointment as an ad hoc advice and consequential benefits which have been paid to the similarly situated employees in the station case for 12 and 12. The petition shall be granted the benefit referred in above within period of 12 weeks from the receipt of this order. So this order was served. Now they say that against this order we have filed it. Now LPA and they also say nothing that the affidavit. They say that the order which
who has to comply?
Chief District Health Officer.
Where is he?
He will be here today.
Tomorrow at 11.
Only a minute, man. There are two.
This order is state.
That's why I'm stating my learned man order is not state. Original matter 12537 of 2020 2011, which has been carried in appeal. Appeal that order has been confirmed. Against which the government went to the honorable apex court. That has been confirmed. Now there is an MCA filed by the government 12537 in LPA.
Is it state?
Yes, add interim relief today in MCA. The honorable court has passed a coordinate bench. Add interim relief terms of para that I have to produce, that I have to say, which my learned friend, not my LPA. My LPA kept on along with all the groups on 26 my lord. But what I am stating, which I have stated in my affidavit, only a minute, Lordship, please to see page number 49, para number 4. He submitted that the present deponent, that is my LPA, but after third line. Now, as the government also prepared a miscellaneous civil application for review in 1 of 2022 in LPA number 1327 of 2019 in SCA 12537 of 2011. Now, in that matter today, in morning, serial number 12, the coordinate bench has heard and up to 30 the order have been filed and interim relief in MCA. So now, original petition 12537.
Add interim relief in what sense it is passed?
Regarding that order of the honorable division bench, that's why that order I have to produce before the honorable.
So division bench order is state.
Add interim relief because I am not having the copy of MCA, which because government has.
Which this special CA number 12537, that is state. Yes, Mr.
That might be that That Reliance on 2011 the main
The
order.
coordinate bench has placed Reliance on 12537. Now that they say in MC it is state.
That I will produce because I was there at 2:30.
So that I can have the.
I was there at 2:30 when the order have been declared. Might be my letter was there. Because there are number of contempts along with the same MPH. All have been kept on 26. But order I will produce within a couple of days. If today I will get it.
You see, he also says that it is state. So we'll see when it is kept.
Yes, my letter is in front also.
Not honorable court has passed the order, issue is the same. No, that is why I request to keep it on 26.
But in fact, the reason for granting of first stay was that not in the proceedings of MCA, not there are directions of this honorable court that there has to be compliance on or before 19th of this month.
Okay.
Hey, not like earlier when the matters were taken by the previous bench and assurance was given to the honorable court that they would not press pursue the content proceedings with the entry of the government is but however they pursued the matter last week before this honorable. Because the honorable court ordered that get the interim order from the honorable court on or before 30 or the orders will comply with by 19. Lord, that is how the matters were heard today by the honorable division bench.
Now when that matters are kept. So we'll keep after that. 20, 54, 26th of this month.
Yes.
So we'll keep it on 30th. 30th, or we'll keep it on 4th of July. 4th of July.
4 July. Serial number 56, Mr. SP Majmudar and Learned AGP.
Please, Your Worship. Page 1. The order of the honorable court, page 1 to 3, they category C, Your Worship.
Yes, Mr. Majmudar, what are you saying?
Yes, the order is MCA 1398.
1398, yes, it's your matter.
The order is not compliant.
Where is the direction?
I appear with the Your Worship.
For some people, it's a
Kindly see what happened. Page 1 to 3, they category C, Your Worship.
You are appearing for whom?
In 139, we go to my colleague.
તમારું નામ તો ખાલી એસપી મજબૂદાર નું જ છે
I also appear.
અને બીજા મુંશા છે.
For you and I appear.
the order is
Page 1 may can be seen what they have committed contempt. In fact, so cleverly they have committed contempt. Kindly see page 1, Your Worship, of the order. And the order is based on the honorable division bench of the honorable court, Your Worship. Can you have a glance at page 1? May I read, Your Worship? Page 1, the issue was that
Yes. પેમેન્ટ આપી દીધું છે.
no, kindly see where
ક્યારે છે? ક્યારે આપી?
The payment was done on 6th April 2023.
So in fact, as per the order of the honorable court, they have to kindly see the operating portion. The issue was
બેસિક પે કયું કર્યું છે એમાં?
page. Can I meanwhile may I?
અરે ભાઈ
They don't have the calculation, but as such for 20 applicants, they have
who are these? How many are there?
20. In 1300 there are 20 applicants.
Yes, what they have paid? How they have calculated?
Yes.
like last time they were to produce on affidavit on payment.
It is not,
It was in Saudi Arabia. In
affidavit is not filed.
No, Your Worship. Even what they have done, they have committed absolute violation of the honorable division.
અરે ભાઈ
bench.
સાંભળો. Yes.
March 4, 2004 till March 2009. Considering that the higher pay is given, I have the calculation. I can share it with my learned friend.
Affidavit ઉપર put કરો.
Please, I will.
Only issue that the NPA allowance is to be treated as basic pay. and accordingly it shall be calculated along with basic pay for the purpose of DNL as on determining. So DA, first you have to say that yes, this is NPA, which is treated as basic pay, and accordingly after taking this basic pay, this DA is paid. Where is there a file and affidavit that explaining whatever you paid?
In fact, I have filed affidavit from my clients, what they have done.
अरे भाई पहले हमने तो Learned AGP request for some time in order for file affidavit explaining the payment made to the all are paid.
All are paid.
Explaining the payment made to the present applicants pursuant to the direction issued by this court. Video judgment dated 7 July 2022.
Sir, can I get one clear? Notice were observed. They have not paid as per the correct calculation of.
पर पहला हमने affidavit कर પછી તમે
Serial number 62 is connected.
62 same 62 payment થઈ છે.
In all the matters.
Affidavit shall be filed on or before next date of hearing. The matter is kept on 30th of June.
Please, Your Honor, can I request more time because in all there are more than 5
But you have to only take one example and the direction. That this was the basic pay. We have this is the dear lens allowance. Accordingly, we have calculated.
Please, I'll do that.
You must have paid to all of them adopting one formula. No?
Yes.
So there is no need to explain all this. You have to adopt. You have to only explain the formula adopted by you.
Please.
Lordship.
30th.
57 is already adjourned. CL number 58, Mr. Sandeep H. Munjasara, and learned AGP.
It is not maintainable. You have a remedy.
As far as the present condition is concerned, it is
166A of the IPC. That is after introduced after Lalita Kumari.
Because this is under the contempt of court act, and as far as the present matter is concerned, there is no bar like that. We have to accept it.
We'll deal with that. Yes. IPC upon. Where are the directions in Lalita Kumari?
Yes, please, Lord. 55, relevant question. Only small submission. If your
Yes.
otherwise, I will not. 55. May I read it to your lordship?
Page.
55 in my petition.
Petition, yes, 55.
Yes, I have the Lalita
Hmm.
Kumari. Paragraph. Article 1, in conclusion, directions in view of the aforesaid discussion. Behold, first, registration of FIR is mandatory for section 154 of the code. If the information discloses commission of a cognizable offences and not bring it during the inquiry is permissible in such a situation.
Yes.
Second, if the information received does not disclose the cognizable offence but indicates the necessity for an inquiry, a preliminary inquiry may be conducted only to ascertain whether the cognizable offence is disclosed or not.
Yes.
If the inquiry discloses the commission of cognizable offence, the FIR must be resisted. In case that during the inquiry ends in closing of the complaint, a copy of the entry of such closure must be supplied to the first informant forthwith and not later than 20. It must disclose its reason in brief for closing the complaint and not proceeding the further. And then, my lord, the police officer cannot avoid his duty of registering offences. If cognizable offence is disclosed, action must be taken against the heading of.
What is the date of the decision of Lalita Kumari?
Please, my lord, it is
12 November 2013.
yes, my lord, November 12, 2013.
Yes. Now go to the provisions of 166A of IPC.
One 160
166A C.
166, yes, my lord. Public servant disobeying directions under the law. Whoever being a public servant, A, knowingly disobey any directions of the law, which prohibits him from requiring the attendance at any place of any person for the purpose of investigation into an offense or any other matter, or B, knowingly disobey to the prejudice of any person, any other directions of the law regulating the manner in which he shall conduct such investigation, or C, fails to record any information given to him under subsection 1 of section 154 of the Code of the Criminal Procedure 1973 in relation to a cognizable offense punishable under section 326A, section so and so, so and so, so and so, shall be punished.
So have you filed a complaint against 166A?
No, my lord.
Then file it.
My lord, my respectful submission is that my lord is right that the additional applicant has an alternate remedy. But my lord, this amendment is carried out with effect from 3 to 2030. But again, my lord, if for the sake of argument, my lord, if my petition was under 226, then
You
my
can
lord,
approach under 156(3) also.
my lord, but only 2 minutes submissions. Otherwise, this is not the case like that. That applicant has the alternate. I mean, has to exercise the alternate remedy and then approach the honorable court for the contempt of court act. That only 2 minutes, my lord, is on merit. If I may be permitted.
We are not concerned with the merit. Do you have any remedy or not? Or Lalita Kumari says that straight away you can file contempt proceedings.
My lord, as far as any of the directions issued by the constitutional court, especially under the honorable piece of the honorable Supreme Court, that the authority is duty bound, my lord, to comply that direction. That is my respectful submission. As far as the contempt of court.
Yes. Anything else? MCA number 1485/2022. Present application.
That learned coordinate benches issue notice to the respondents. What they have done, my lord, as per the, my lord, I am relying the rules framed under the section 23 of the Act of 1971. My lord, wherein rule 16 says that they have to file affidavit in their defense. My lord. They have not filed affidavit.
We have not issued any.
Yes, my lord, not. The honorable court was kind enough to issue notice to the respondents. That's why-
So we are saying that we will dispose of.
But my lord, once notice is issued, then the Gujarat High Court rules from 1984 has to be complied by the respondent. That is my respectful submission.
We'll deal with that also. आपको जरा high court rules.
So if your lordship.
Contempt of courts rule है आप जो.
Your lordship permit only to.
एक अंतर टीम मिलाने के लिए. आदित्य से Yes.
One more minute, my lord. As far as section 166A of the IPC is concerned, my lord, wherein in clause C, wherein it is alternate remedies there, but it is qua.
What about 156(3)?
My lord, that there is a option. Yes, my lord, I agree.
Under which provision are you seeking these contempt proceedings to be initiated? 2B or 2C?
2B, my lord, civil contempt, my lord.
Is there any willful defiance?
Yes, definitely. That's why I want to point out only 2 minutes on merit. It is deliberate and willful disobedience of the directions issued by the honorable Supreme Court.
Where the Supreme Court has stated in Arnesh Kumar and the DK Basu, there are specific direction. If non-compliance, then contempt of court. Where is that in this case?
My lord, it is natural consequences. If the directions issued by the constitutional court, if it is not followed, then definitely.
Then the contempt would lie to the Supreme Court.
My Lord, as per section 12, this honorable court has power to,
We can't.
Lord, yeah, it is section 12.
We'll deal with all your content. MCA number 1485, but section deal kar de.
Lord, is small accommodation may be given.
No,
Or
the present
some
application has been filed.
Similar matter has been kept regarding Arnesh Kumar.
Arnesh Kumar is different. There the directions are there for seeking following prayer 17A. Thus, the prayers clause would suggest the petitioner. Yes,
What is application we have already communicated that once investigation was done, therefore no offense is made up. And this was also given to my learned friend.
oh yes. Okay.
Lord, in this regard, I may permit you this additional to answer that.
The prayer clause would suggest that the petitioner is seeking the directions for initiation of contempt proceedings in violation or disobeying the orders passed direction issued by the Supreme Court in case of Lalita Kumari versus Government of Uttar Pradesh, reported in 2014, volume 2, SCC, page 1. Next. It is a case of the petitioner that he received information including under RTI Act regarding fake certificate of experience of one Mr. Ravindra Chauhan in the month of September 2021. Thereafter, various complaints have been given by him to the police authority who registered the FIR. However, the same is not registered. At the outset, learned AGP appearing for the respondent authority submitted that the concerned police inspector of Dantewada police station, while examining the complaint of the present applicant, has opined that after necessary investigation is done, the application filed by the petitioner has been filed since no offense is having found to be having committed by Mr. Ravindra Bhatt. 4 point. Learned AGP has tendered the communication dated 17 February 23. Communications review. The same are ordered to be taken on record. Learned advocate, Mr. Swens has filed an additional affidavit of the applicant dated 13 June 23. The same is also ordered to take on record. In the affidavit, the applicant has categorically tried to establish that in fact the certificate of Mr. Ravindra Chauhan is fake, and even one Mr. D.U. Waghela, managing director of the corporation, is also involved. Of Gujarat State Seeds Corporation is also involved. 4 point. Reliance is placed by learned advocate Mr. So-and-so on section 12 of the Contempt of Courts Act as well as Rule 16 of Contempt of Court, Gujarat High Court Rules 1984 in support of his submissions. It is submitted that there is blatant disregard to the direction issued by the Supreme Court in case of Lalita Kumari. Hence, the petitioners, the respondent authorities may be directed to comply with, and contempt proceedings may be initiated. 4 point. Next. Now, it is also submitted that the respondents have thus committed contempt of courts act under section 2B of the Contempt of Courts. 4 point. We have heard the learned advocate so and so, so and so. From the aforementioned facts, it is manifest that upon the application filed by the petitioner, the investigation was done by the concerned police officer And accordingly, the application filed by the petitioner has been filed. And he has been communicated on 17th February 23. 4 point. The petitioner has also an alternative remedy under the provisions of section 160(56)(3) of the CRPC to file a private complaint before the magistrate, read with section 190 of the CRPC. 4 point. We do not find that there is willful deliberate disobedience by the respondent authorities in ignoring the direction issued by the Constitution Bench in Lalita Kumari case, and they have made their efforts and accordingly filed the complaint. Thus, the petitioner can avail appropriate remedy. Hence, the present application seeking contempt so and so is not entertained, same is rejected. Notice discharge.
Not say anything directed to Radha, but the police officer has taken their statement as a managing director. That is the crux of the matter.
We'll modify accordingly. To affidavit pramana affidavit. It contains. No, next. You withdraw then only. Sure.
59, Mr. Vivek.
Come by 4:45.
59, Mr. Vivek P. Gupta and Mr. Dilip Kanotia.
So page 33 is the undertaking, and page 20 is the order of which willful disobedience is coming. What I think you undertook to page
Who has? Which page?
33 is the undertaking. So this is for breach of an order of maintenance by the husband, respondent who is a husband, who is a husband. And the undertaking 33, wherein he says that he will deposit 20% of the amount which is outstanding as on date of the undertaking, which he has not done. But page 20 is the order granting interim maintenance to the wife petitioner, 20, wherein 13,000 rupees per month have been granted to him. He has not paid a single penny worth them. The son is with me from 2019 onwards.
Who appears for him? For opponent?
Yes.
Yes, what is your stand?
One is an executable order. If the lordship would have the order is passed under the Domestic Violence Act. Section 26 of the Domestic Violence Act provides for execution of the order, which he has already done. If the lordship may go further, next page that is 34. So what transpired was pursuant to an order, the undertaking was by
44.
You may take appropriate steps, including arrest. I take your lordship to the end, but before that, if your lordship would see, my application is dated 3rd of September 2022 at the bottom on page 33. Immediately thereafter, the next page, page 34, which is 6 days thereafter, at the top on the left, it is mentioned 9/9/20.
Yes.
So within 6 days, he has already prepared an application for distress warrant.
Then what happened?
It was allowed. The next page is the order, page 35. And this is only with regards to the undertaking which I am showing your lordship. As far as the main order is concerned, there also he has filed execution. I have already challenged the matter is pending before this honorable court. But page 35 is the order whereby that warrant application was allowed. Page 36, after about a month thereafter, that is in October, he again files an application for NPW. And there he specifically again talks about the undertaking which was given to the court and he says issued NPW. And there also at the bottom, if your lordship would see, સામેવાળા વિરુદ્ધ જંગમ મિલકતી
જપ્તીનું વોરંટ કાઢવું.
He has already undertaken all the process pursuant to the undertaking. He has already prepared an execution application before the concerned court.
Where is the execution? This is the execution application.
No, all this was done before the concerned court is under the protection of the Domestic Violence Act.
Where is the execution application?
Yes, I just. It was under section 125(3) of the CRPC. I just.
You have challenged before this court?
That execution was allowed. I preferred an appeal against that order.
Where
My
is that?
appeal was rejected, against which I
Have you filed affidavit in the matter?
No, I had taken last time,
Then
I
you-
had given it to the client, affidavit has not come in the record, but this is the case, and we have already.
You see, then you have to file it
Yes,
so that
yes,
this court can deal with it.
Yes.
Learned advocate, Mr. So-and-so, for Mr. Kanodia, for the opponent, request for some time in order to file an affidavit. The same shall be filed on or before the next date of hearing. Matter is kept on 30th of June.
None of the orders have been challenged, they have become final in my lord. After passing of the interim maintenance order, he has withdrawn 5 lakh rupees from his bank account. A
So
copy
we
of
are
the
concerned with the when we have already, first let him file the affidavit, then we'll
willful
continue.
disobedience.
We'll see.
Serial number 660, Mr. Darshan Kumar R. Kabra, Mr. Manish M. Kaushik, Mr. Bhargav Asukar.
Wait. Yes, it is your application.
No, it is my, I am the application.
You are for the applicant.
I am for that.
On the request of learned advocate Mr. Kabra, matter is adjourned to 3rd of June, 4th of July.
We are facing some problem in our IPOs which is coming up.
28th June. Chalo. 4th.
Sixty-one, Mr. Girisham Das, 6 notes.
In view of 6 note of learned advocate Mr. Girisham Das, the matter is kept on 11th of July.
62 is already adjourned. Serial number 63, Ms. Kruti M. Shah and Ms. Lilu Kebaya.
Is there any stay against the direction issued by this court? Is it stayed? Comply. When? We give you, point out the order. Comply with the subject to result of SLP. Notice is issued.
Now the Supreme Court first court has decided that issue about the earlier
Where is the order of the Supreme Court? Where?
Now I will visit the court, madam, since it is decision, it is kept on 9th July, page 44. When you release the condition without area with the amount, then also I will. One of 7th January 2022. Now it is kept on 4th.
Comply subject to SLP.
I am not, like, we have brought the notice of the Honorable Supreme Court also that contempt petition is filed.
Then we don't have any order.
That is simply because of petition it is kept on 4th July. I will,
You have to say that Supreme Court has observed that for interim order, we will be hearing or the matter is kept after beyond vacation. Where is that? This is going on since January 2021, year has passed.
but later only I am having a new order. My advocate sent me a letter.
Page 39, the order passed in LP.
Yeah, that is there. I am not disputing any of those factual aspects. I am only drawing that now Supreme Court has the larger than decided issue also, and it is kept on 4th July. Because of that, it was not taken up on 5th
Larger bench of
Supreme Court, my Chief Justice, and the 2 other things have decided.
this issue.
Yes,
What is the issue?
earlier use whether we are correspondent with judgment is there, then whether earlier use are required to be paid by the subsequent purchase.
What is that is against you or in your favor? Then you comply
It is in my favor.
in your favor.
Yes.
Have you gone through that?
See, I given a judgment also. That is delivered on 19th May.
But the constitutional bench has refused to take up this matter along with that matter. That is also a fact that the court has declared that will not hear this matter along with those matters which were disposed of and which that the order is in favor of by the court.
It is from 19th May. This 19th May judgment, I can prove it.
They have made a request that this contempt is pending. This is what you have conveyed to me. I don't know anything.
No, don't argue it.
The 19th
You
May,
may-
the judgment, Lordship, what I can put it on record.
Ms. Bhaia, that judgment was, now this matter was lastly listed before Supreme Court when?
That date also I will in my life. I given it on, it was on 9th May.
9th May and 10th May.
Yes, 9th May or 10th May. And this judgment has come on 19th May. So it was kept, so they have kept it on 4th July. That's what to say, I will.
Means go to the judgment, otherwise you have to comply with does not cover it.
Judgment right now.
Honorable Supreme Court has stated that the earlier dues have to be paid, even if it is by the auction purchaser. However, the amount of the interest has been waived off in respect of the persons who have purchased the property by way of auction.
No, it is, it was all yours is a private transaction, but it's an auction.
So ultimately, you see, the division bench has dismissed your appeal.
You can't recover the dues of the earlier consumer. That is the issue. There were some, the circumcision has committed theft.
Then why did you invite, why this order, why this matter? You did not ask to be tagged along with this 19th matter, which was
We
already.
made a request and the court has refused.
This matter was CAV. It was heard in the Honorable Supreme Court has kept it CAV, and that CAV judgment has been delivered on 19th. This 223.
But then you could have requested at that time when the matter was to take place.
Quite a some time, I think 8 to 9 months before. it was-
Any
For
judgment where
CAV.
in that judgment of CAV judgment, any order of this court is also any
Yes,
matter of
there
this
are
court
5 matters of this order. All judgment has been passed and.
we'll keep it on 2nd of July. Carriage.
Sunday.
We'll keep it on 6th.
Yes.
You see, if we don't obtain orders,
Automatically comply. If it is not granted,
Ah.
Lordship may have to sure I will.
6th.
64, Mr. Nishit P. Gandhi and Mr. H.S. Muncha.
Thirtieth June.
Second submission is which matters? And second submission is the honorable court is executing both these contractual appointment as well as ad hoc appointment.
Page 68.
Third submission is that my LPAs are.
Yes, the same 12537 is related.
As a contender and a submission जब दी गया और तो चालू होती कर
This page 81, the matter which is referred is already state today. Direction is state by the division bench.
but I am not concerned with page 80
81 12537.
now. Okay, now your watches page 80 your watches is para 14. It refers to
Page
some
81
special
para 6. Page 81 para 6.
Sir, agreed. Sir, but sir, please see one page before, because this direction refers to special civil application mentioned in para 14 where I am not there. I am in some other group. Can I just indicate that?
Page
agree, sir, I agree.
in the one matter, right? This very same order was cited.
I know, madam.
Page
Sir,
82
yes,
para
appeared
14.
the review in special CA 12537 of 2011
Ah, now it is state.
is correct. But what I'm saying is, that your watches have this para 14. Your watches are reading page 81.
82 last directions. Page 82 para 14.
Sir, your watches have the MCA 395.
368.
on this.
Page 82 para 14.
Page 82. Yes, sir. Now, para 14 refers to those special civil applications.
No, last 4 lines.
Correct. But this matter 5040 is not appearing in para 14. It appears.
No,
on
no,
page
this
71.
last 12537 so and so. Similarly situated name so and so. Now this 12537 is state.
Correct, but this contempt is filed in special CA 5040 of 22.
But this order is premised on this. No?
Sir, but sir, a para 14 mas sir 5040 nathi aati. It comes in on page
But
71.
we have to see the issue. If the entire direction which is premised on 12537 is stayed, all these matters will go. 30th, 30.
Other matters are kept.
You put efforts before the division bench.
Sorry.
Before the division bench, put efforts in that matter. Then only you will get benefits in this.
69.
They should join me as parties, sir. I am not there.
You can, Mr. Muncha, rope him in.
Not there are,
You will exclude me.
not, I am sorry.
કે આવી જ આટલી બધી મેટરમાં તો આવી જશે જ્ઞાન ને ક્યાંક આવી જશે.
Mr. Manish Patel is kept on 4th July.
4th July.
Very well, whatever.
ये પણ હોય એ તારીખ.
In 69, since there are three matters, in 69 there is no appeal file. So that part I am receiving. But it
But this will premise on 12537. All these matters emanate from that only. Now that is state.
4th રાખી છે Mr. Manish Patel.
ક્યારે?
Mr. Apurva Kaparia and 4th July.
4th.
This is basically the cause of all. Multipurpose matter.
right.
4th.
75 to 77.
So the LPS would also be before the same bench, no, Mr. Muncha?
No, before this is a.
Oh, so MCS before another bench and LPS are before another bench.
Yes, I recollect. My lord.
So, Holy Trinity.
Shastri was,
Also-
Shastri was,
So, and my lord just get transferred to contempt is also last week, before vacancy.
Sir, બધું સાહેબ એક જ બેન્ચમાં કરી નાખો. All either before your lordship, sir.
That
or-
you, Mr. Muncha, and you can do it. You are capable of convincing them.
79 भी है.
Somewhere you are also not equal caliber.
So, no, no, we really intend to spring a surprise on 26. When those reviews. My consolidate. Right.
Just spare us.
66 Mr. N.K. Majmudar, DS appeal not filed.
This is the matter.
Where are the directions?
Please, your lordship. I also can have a glance at page number 10 to 22, but the relevant observations.
Page 29.
Page, another single judge, lordship, kindly have a glance at page 19, para 11. In sum and function, may I submit?
अरे page 29 ऊपर आ जाओ, para 10.
Honorable LPA bench, page
આમાં તો મેં લખી છે.
in that view of
હા,
the
બધામાં
matter,
ચાર.
declaration of present of the clause moderated and by placing the submission on undertaking given by the Nugget Council FA for the respondents 1 and 3, as also submission made by the Nugget Council FA for appellants, which indicate that appellants could also not encumber the suit scheduled property and create third party rights. These letters pattern of the stands disposed.
So they were directed not to create third party right.
Lordship.
Then
And
what they?
even appeal was dismissed and Lugard single judge was the order of the Lugard secretary who had caused the entries by which my names were appeared. In fact, some and substance.
So,
Present appellants and respondents are related.
so who has committed contempt?
Now, so our names were ordered to be replaced as a consequence of the order of the single judge.
Yes.
Order to be entered with respondents. Now, kindly see the impute order page 35 to 53. The diagonally opposite order is passed, page 35. Removal of upon name would allow voting against the Lugard single judge, page 35 is the order. Straightway can we have a glance at. I draw your lordship's attention only to very relevant.
Yes, who appears in this matter? There is no reply. You have
I have given.
violated the direction and passed the contrary orders of observation made by the. Yes. You have referred to the order also, page 53.
Page number 29. If I may read what my learned friend has read, paragraph number 10.
Yes.
In view of the matter, continuation of present appeal is not warranted by placing the submission and undertaking given by the learned counsel appealing for this order 1 to 3, and also the submission made by the learned counsel appealing for the appellants, which is to the effect that the appellants would also not encumber the suit, children property or gain in third party right. This LPA stands disposed of accordingly. In my humble submission, there are no direction for us. Both the private parties have by consent got this order. The division bench as well as the honorable the single judge has not opined as or any direction for us. Secondly, my lord, there is no contempt notice issued to us. Only a represent to the SP has been issued.
Yes, Mr. Majmudar.
Now kindly see page 21.
You better file affidavit explaining it.
I shall.
Learned AGP request for some time.
No contempt notice is issued to us.
Suppose if it's in direct violation, the order is passed, then there is no need of contempt. We have to go to the contents of the order only. There is a direct contempt if contrary orders are passed. In only those cases where there is no compliance, the notice is required. But suppose if you file diagonally opposite order to the direction, then they have only to invite the attention of this court.
I said there are no.
Explain that. An AGP request for some time in order to file affidavit and reply. Same shall be filed on or before next date of Mary, 4th of July.
67, Ms. Shikhati Panchal and Mr. Manojan Popat. Leave note. Attention થાય છે.
So about the already discussed, and I would like to mention, affidavit like this is also fine. We have already discussed this, but I think what the law is.
Yes, do you have
Some
it?
amount is paid, but they are not paid the major amount. So after 2 weeks, let them, the amount has to be paid. Because Supreme Court has given a direction in this case. Even to the Supreme Court has given a direction that you comply with the High Court's order within 8 weeks.
So they have filed, this affidavit is not on record.
It's not. I have got, yes, I have got a copy.
Okay, so same date. When do you want? 2nd July? Oh, sorry, 4th of July.
Simply. 68, Mr. Deepak N. Joshi.
Fourth.
69 is already adjourned. Cell number 70, Mr. Tulsi R. Savani. Response are served.
Order is stayed. Don't press. Not press at this stage. Sure.
#71, Mr. Vyom H. Shah. Response are served.
That the higher pay scale has to be given. It is pension is to be revised. My instructions are that would be also be done within 2 weeks. So this is also part of compliance. Kindly see.
No, rest of them they will say. They say that they will do it.
For the amount that they have given to me, that is also not compliant. Kindly see, the order that is set aside is of 2012, by which my both the higher pay scales were withdrawn. For both the petitioners, so for number 71 and 73. One of the petitioners was retired in 2018. He has been
The orders withdrawing the higher pay scale in case of petitioner are questioned set aside. Consequential benefits that a petitioner may be entitled to based on questions shall be granted within a period of 10 weeks. So which would be the consequential benefits? First would be the higher pay scales. So that they have already done.
So the amount is not.
That is what the order they will pay.
It is already paid.
Then-
For one of the petitions, we have paid 30,000 rupees. And for another petition, that is a serial number 73 minutes, we have paid 3 lakh rupees. Both the petitions, because their order has been withdrawn on the same date, because in 2012.
There is no willful defense. Upon which number?
73 minutes.
73 पण आपको MCA number 404 with so and so.
One petition has been paid 10% of what the other petition has been paid.
Listen to the order document. When the matters are called out, learned AGP has submitted that the direction issued by this court are complied with, and accordingly the benefits to the petitioners are paid. Full point. He has forwarded the order dated 12th May 23. The same is ordered to be taken on record. In the next matter, is there separate order? Same.
Same order.
The same are taken on record. As per the order, the petitioners are paid an amount of 3,05,030 rupees. Whereas in other, how much?
30.
Where is the other?
Same.
34,005. Full point. Learned advocate Mr. So and so appearing for the petitioner is disputing the aforesaid amount, and it is submitted that the petitioners are entitled to more amount than what is paid to them. Full point. Next. In the present applications, the petitioner is seeking compliance of the direction issued by this court, more particular in para 10 level. Thus, the perusal of the aforesaid direction would reveal that there is no direction issued by this court paying us, directing the respondents to pay a specific amount. Full point. The authorities in their wisdom have calculated the amount and have paid to them. If the petitioner is aggrieved by such calculation, he can file appropriate proceeding before appropriate forum. Full point. It is no more eccentric that contempt proceedings can be initiated only in those cases where there is willful and deliberate non-compliance of the orders. The Supreme Court in case of Ram Kishan versus Tarun Bajaj reported in 2014 volume 16 SEC page 204 has held thus para 1011. Thus, if the petitioners are aggrieved by the calculation and payment of the aforesaid amount, they have a remedy for filing appropriate proceeding before appropriate forum. The pension benefits is also not paid. So the learned advocate Mr. So and so on behalf of the petitioner submitted. Learned AGP has submitted our pension.
Pension will be revised if applicable, because there are 2 applicants.
Okay. Learned AGP on instructions of so and so give the officer submitted that the pension of the petitioner will accordingly be revised in case the same is liable to be revised.
Within 2 weeks.
Within period of 2 weeks. Rejected.
Per court board serial number 4, party in person, Shabana Banu.
Two weeks. पास हुआ रहता है कोई
ना बीजेपी एक ले मेंशन करवाने के लिए 49 मेंशन करवा
49 નથી ના
49
વિભો વ્યાસની નથી
ના સોરી 49 પતા નહીં जिन मुंजा सर 58 sorry
हाँ
serial number 58 Mr. Sandeep H Munjasra फिर बेबी का अठवाडिया पता
yes rejected.
$72 Mr. Ramesh Bhai M Patel.
Applicant.
It was for all the applicants.
Have you referred about the withdrawal of the application? Contempt application in your application, Mr. जरा जो ना 804 of 2022 में कितना petitions
15.
એમાં આ છે પટેલ જાનુ રોહિતભાઈ.
Yes. Serial number, applicant number
Cost of
6.
10,000. MCA number 410 of 23. When the matter is taken for hearing at the outset, learned AGP has tendered the order dated 14/11/2022 passed by MCA number 804 of 2022 and has submitted that the petitioner had earlier filed the contempt application being MCA number 804 of 2022, which was withdrawn and disposed of video order dated 14/11/2022. Full point. Next. The present application is filed by the petitioner who was the applicant in MCA number 804 of 2022. Cover number, applicant number,
Applicant number 6.
applicant number 6.
Objection that I have passed the HSC and
You have not referred suppression of from the contents of the application. It is noticed that the applicant has made a specific statement in paragraph 7 as under paragraph 7. It is stated by the applicant into bracket petitioner that he has not filed any other petition any or the court of law with regard to the subject matter of this petition. Full point. Thus, there is apparent suppression of facts as the petitioner has suppressed the filing of the MCA number 804 of 2022, which was withdrawn. Full point. Has the present application is rejected with the cost of rupees 10,000, the same shall be deposited before the registry within a period of 2 weeks. We have verified it. Pardon, Mr. Yes.
I have no address of my client. Question about this court. Both of them possibly have died. Therefore, available warrants have been issued by this court. That has also not come back.
સર આમાં મને કહી જાય ઇક્વિટલની બે અપીલો એમાં ફ્રેશ અવેલેબલ વોરંટ ઇશ્યુ કરવા પડશે. ઇક્વિટલ 1026 and 689.
એમાં કે ઓલરેડી મંગુકિયા કહે છે કે ભાઈ ઇશ્યુ કરેલા છે અને એક્ઝિક્યુટ નથી થયા.
એ લોકોને કઈ મળતા નથી કે
Available warrant sent to the GP office.
આ પણ નથી જોઈ
Last column not
To what shall we?
ફ્રેશ કાઢો મને
ફ્રેશ કાઢવાના 90 બધે ત્રણે ત્રણમાં
If it appeals to my lord, let my London friend find out from the police lord that whether this person is alive. If they are dead, there is missing time.
આ તો એવી રીતે પહેલા વેરીફાઈ કરવા જોઈએ પેલા જેવું.
Which on three, all the three appeals, or sorry, two, this 2, 3, 5, and one is of state.
One is of state, Lord, the Harjit Singh and the
એક્વિટલમાં
Harjit Singh.
કીધું છે
Both are Sahdev.
એક્વિટલ બે છે ને 1026 and 689.
And I am told that both have died. So their numbers which is given in 2005 are
What about this Hati Singh Nagji bhai?
both have died.
Learned
Both.
APP, sorry, learned advocate Mr. Mangukia had submitted that as per his information, the accused Hati Singh Nagjibai Mavi and Sahdev Nagjibai Mavi, both of them have passed away. Learned APP,
But I don't have the exact.
however, he is not having the exact information. Full point. Learned
Lines
APP,
are not the contact. Otherwise, I
learn-
worry for it.
તમને સાચવી લઈશું, don't worry. Learned APP shall inquire about the same, since it is also noticed that available warrants issued to the concerned accused have not been executed. Necessary information with regard to the aforesaid persons shall be taken by the learned APP by the next date of hearing. The matter is kept on 28 June 28.
Serial number 81 can be withdrawn, it is already complied. My letter is here.
Mr. Singh, 81 withdrawn, as for not pressed. 81 not pressed.
Please, be clear.
74 tomorrow कर दे. આવી જશે.
હા એમ કરું છું.